Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Hello, my lovelies and my handsomes. How are you guys this Saturday? Let's shrink Jay down a little bit. Welcome to J is for Justice. I see we've got some wrenches in chat. You guys want to pay attention to the wrenches because they run the show here. We've got Shell, Snow, Potato, and who else do we have wrenching it today? Looks like nobody. Those are your three wrenches today, guys. Give a warm welcome. And Rose. Rose's replay crew, though, she said. And I want to welcome the members, which are lovingly known as Roberters and Robertolinos. Jen Isley Brothers, what up? Northern Beans. The Ultra Dark CEO has many accounts. So welcome Ultra Dark CEO's persona to chat today. Sharon Tuck, Bella Blonde, Tiffany Lee, Cindy Blakely. Of course, the one and only Megs, Mandy S., and Tough Tiff, Rex. Hope I didn't miss anyone. So, hello Eileen, and hello all new Roberters. Hello Audra D, and hey Megan Elsa. She says happy fall with the jack-o'-lantern and the leaf. Are you guys getting some nice colors up north? It is a beautiful day here in Tampa Bay. So, hey, Carrie, it's the one and the only. They're all going to laugh at you, Carrie. I still don't have my sound bites. What's up, Sharon Tuck? Okay, so we are going to watch a hearing, and it is pretty long. So the runtime on this hearing, and I have to warn you that there is some explicit language, so viewer discretion is advised. But it looks like this has a total runtime, you guys, of about almost 5 hours straight. Hi, Debbie. Oh, happy October. That's right. It's October. It doesn't feel any different here. I mean, it's cooled off. Angie B. It's cooled off. Hey, Mike Sanner coming in hot with the merch link. But, okay, so it's going to be a runtime of about 5 hours. I am literally outside painting my windows. So this will give you guys, if you're doing some projects or cleaning your house or doing whatnot, I figured this would be a good day to play this in its entirety. I can listen. It'll give us some good listening stuff for this Saturday. Then how's the Michigan colors? Ange Carter coming in hot. Wants to know how the Michigan colors are this year. Is it still early for those or? Not sure. It must be starting though because it's getting cool up there. Okay, so if you're not familiar with the case of Harmony Montgomery and who this character Adam is her dad, and he was indicted on one Class B felony of second-degree assault that authorities say occurred between July 1st and July 22nd of 2019, when he knowingly caused bodily injury to his daughter Harmony Montgomery by striking her in the face. Montgomery's estranged wife, who is Kayla, was indicted on a Class 1 felony charge of theft by deception. And that alleged that approximately between November 30th of 2019 and June 2nd of 2021, she told the New Hampshire Department of Health and Human Services that Harmony was living in her Manchester household when she wasn't. And Kayla collected $1,500 in state benefits in little Harmony's name. So she was charged with that. Now, at the time of Harmony Montgomery's disappearance, Adam had custody of her. And you're going to see in this hearing, there's body cam footage of him refusing to talk about his daughter to authorities. But Harmony went missing in, they say approximately between, I think it's November. Wait, let me get the dates absolutely correct. Between November 28th and December 10th. But police did not find out that she was missing for 2 whole years. But they do say that all the evidence that they have collected and leads them to believe that Harmony is deceased. And back in June, they raided a place that Harmony lived with her dad, Adam, and her mother, Kayla, and they took out a refrigerator. They wrapped it in black plastic and they took it. So he's also accused of unrelated firearms theft charges and has pleaded not guilty. Now, no charges have been filed directly with Harmony. They haven't found her. Ange Carter, happy fall to you. And thank you for becoming, that's 7 months you've been a Roberter.
Roberta.
And Carrie, happy October, Roberters. Thanks for all you do, Jay. Thank you, Carrie. 9 months.
Roberta.
You could have had a baby in that amount of time. That's freaking amazing. Snow, welcome back to Roberta in Training. Nice to see you there. Thank you, thank you, thank you. Okay, so let's move forward and let's start this hearing. Like I said, it has about a runtime of about 5 hours.
Roberta.
So whatever you're doing, get cozy, get comfy. If you're on replay, enjoy this hearing. Again, viewer discretion is advised in this one. Whoop, whoop. You're a Roberta baby. I love it. I love it. All right, let's get this on the screen for you. Well, and for me, because I haven't seen this yet. I had no idea that this even happened. And I came across it because I'm like, oh my gosh, we haven't seen anything about Harmony in so long. So here we go. Let me make sure you guys have sound. I know y'all can hear me loud and clear. And I want you to be able to hear them loud and clear. Okay, here we go. And thank you guys for being here. Happy Saturday.
All right. Good morning, everyone. We're here in the matter of State versus Adam Montgomery. Counsel for the state, please identify yourselves for the record.
Good morning, Jesse O'Neill for the state.
Good morning, Your Honor. Benegati for the state.
Caroline Smith, the public defender, present with Paige Buckley and Adam Montgomery.
All right. Good morning. So, we are here on several motions to suppress, as well as there are some preliminary motions related to the expert. And I don't have a responsive pleading on that. I know it was only recently filed and the 10 days hasn't run, but since it's going to potentially impact.
Is it loud enough, you guys?
How we proceed this morning, I guess I need to hear maybe from you first, Attorney Smith, as to what your view of that is.
Sure. Different file, sorry. First of all, the state has raised the issue of reckless misrepresentation in the affidavit, and quite frankly, that is not what I raised in the pleading, and it is not what I intended to call Mr. Gorecki with regard to. What I raised in my pleading was that the affiant, Michael Valenti, did not present qualifications to offer his opinion on the depth, the need to go into the depth of the phone in order to recover what was sought to be recovered, which was a specific limited time period. And relying, in essence, what I'm saying is the judge relying on that is like relying on somebody saying, so-and-so told me so-and-so had drugs, without the appropriate foundation and source of knowledge. The magistrate can't rely on so-and-so saying so-and-so has drugs.
So let me just ask you, so do you agree with the state's position that essentially what you have raised is the question of whether there was adequate probable cause within the four corners of the document and not the issue of?
That is correct.
Okay.
That is
So, and
correct. However.
Hold on, is it still your intention to attempt to call that expert today?
Yes.
Okay, so go ahead.
However, having raised it, I've thought about it, and quite frankly, it is an issue. So today, I'll probably be presenting through Richard Gurecki the information about the material misrepresentation and then file the subsequent pleading. But it was and is my intent to call him with regard to, and essentially what I'm saying is Mr. Valenti, Detective Valenti did not have the foundation to offer that opinion, therefore the judge could not rely on that. And to the extent, as the state put in their response, it's sort of understood. To understand something that is wrong is not common knowledge that can be relied on.
Okay, but what I'm hearing you say is, although you want to go forward with it today, that you agree that your initial motion did not address the misrepresentations, and as I understand the state's motion to exclude him, there's then an issue of notice. And so I do think that that's a problem. Do you not agree with me that they would have a right to, review the arguments in advance of the hearing, see who your expert was going to be, decide if they needed to call Officer Valenti and an expert themselves, and that all of that cannot happen today?
I agree.
Okay.
However, Mr. Gurecki still speaks to the four corners of the document, that if the state is arguing, as I think that they are, that it is common knowledge, it is not expert testimony, and that the judge could rely on it, it is not common knowledge if it's error. And so that's what Mr. Gurecki will be testifying to.
So it's your view that he's just going to testify today that the fact there wasn't adequate, he's going to testify that there is an adequate foundation in the four corners of the document that would allow Officer Valenti to make the assertion that he made? I mean, isn't that a legal argument? It's not really a...
To the extent that the state relies on Page, State v. Page, where the court was allowed to use some common knowledge to understand that photographs can be manipulated, which is true. Photographs can be manipulated with regard to where they're put in a file and things like that. The judge in State versus Page relied on common knowledge. And they produced an expert in Page to describe to the judge why they had to go so deeply into the phone to make sure that they caught all the evidence. This is essentially an assertion, and to the extent that they say that the judge can use his common knowledge that things can be manipulated on the phone, that is not so, because I'm talking about very specific areas that the state requested to go into, which was any and all communications, any and all social media, any and all contents, any and all this, that, and the other. That is not the type of thing that can be manipulated that would allow somebody to believe that they had to go through the entire phone to find out information about a particular 4 or 5 days.
All right, I'm going to hear from the state first. I think the fact that you need to go this deep to explain this to me goes to the issue of notice, which is both the court's notice to be able to review what the arguments are, as well as the state's notice to be able to fully litigate this issue. So I am concerned about that, but let me hear from the state.
Thank you, Your Honor. So it sounds like the court has hit the nail squarely on the head, so to speak. The issue is that the defendant's motion challenging the search warrant raised four corners issues, going to an argument as to the lack of probable cause to support the issuance of the search warrant, which would be, to the extent the defendant argues that there was some sort of lack of foundation of Detective Valenti's knowledge or expertise, that would be a four corners argument that would go directly to whether or not the affidavit provided the requisite probable cause. It's very clear, and the state outlines this in paragraph 8 of our motion to preclude. There's a very clear framework for when a defendant is entitled to an evidentiary hearing to challenge a search warrant affidavit. Search warrant affidavits are given deference. The issuing judge, basically the trial court is sitting in a sort of a quasi-appellate review of what the issuing judge did, and for that reason, the search warrant affidavit is given deference. And only if the court decides as a matter of law, this is from the STEM case cited in paragraph 8, only if the court decides as a matter of law whether the affidavit contained a misrepresentation and whether that misrepresentation was material, only then is the defendant entitled to an evidentiary hearing about the affidavit. And that just simply hasn't been met.
But, I mean, to some extent, would you agree that so long as they make an adequate offer of proof, I mean, that the defense may need to call witnesses to establish that misrepresentation, right? I mean, it is possible that it's not going to be clear on its face. In any given instance, for example, let's say an officer testifies in an affidavit of a certain fact, and there is evidence, not within the affidavit, that that fact is untrue. That, so long as they make an offer of, a good faith offer of proof on that issue, that would allow for an evidentiary hearing on that sort of non-four corners issue, right?
I would say potentially. I note the STEM case does make these determinations a question of law, not a question of fact. I'm certainly not going to argue that the court can't take an offer of proof, but the STEM case is very clear, quote, whether an affidavit contains a misrepresentation and whether the misrepresentation was material are questions of law. These aren't questions of fact, and quote, questions of law. But I'd also note that just whether or not there's a misrepresentation, so the example the court just gave about whether there's some fact in an affidavit that turns out to be untrue, it's not just the misrepresentation, but it's also the misrepresentation being material. And as the state explains in paragraph 13 of the motion to preclude Mr. Gorecki's testimony, the affidavit, which is attached to the motion for the court's review, the affidavit contained a detailed recitation in paragraph 42 of the affidavit as to the probable cause and the basis to search each of these various items on the phone. So to the extent...
But it's not just the items on the phone, as I understand it. It's also that there's no temporal limitation whatsoever on that. Am I understanding correctly, Attorney Smith, that that's... Okay.
Correct.
So it's hard to argue that there's no materiality if you didn't have to look outside that December 27th to, I think it's the 31st time period, those statements are potentially material because that's what got you outside that time frame, in addition to what got you
but
through
there's
additional
two.
information.
So paragraph 42 of the probable cause statement for the search warrant also goes through and explains why there's a need to search beyond just that time frame. So the definition of materiality is basically necessary for the issuance of the warrant. And that's coming from the Valenzuela case. The police made knowing or reckless misstatements that were material in the sense of being necessary for the finding of probable cause. So it's the state's argument that if there are two separate and individual bases for a search, and let's say one of them does turn out to be a knowing or reckless misrepresentation, it's not material in the sense of being necessary for the finding of probable cause because there's another completely separate basis for the need to search outside of that time frame. So in addition to just whether or not what Detective Valenti said was accurate, there's that question of materiality, and paragraph 42 of the probable cause statement is a completely separate basis to go outside of that time frame.
Just give me one moment, please.
I'm sorry, which one did you quote for going outside the time frame?
Paragraph 42.
You said paragraph 42 of the affidavit, of Valenti's affidavit?
Yes. Let me just double check that I'm not misspeaking. Yeah, paragraph 42.
Can you just repeat what you said about that paragraph, please?
Paragraph 42, so it's a long paragraph broken into many subparts. It starts on page 14 of the affidavit. It goes through and explains why it's necessary to search all of these different areas, including, for instance, 42D, any text or MMS message, incoming, outgoing, sent, draft, deleted, saved/stored on the device, will be valuable evidence tending to prove ownership, possession, custody, and control of the device. And this is something that the state gets into much more in its motion to preclude, but let's say there was a text message from 5 days prior that says, hey, this is Adam. That would be valuable evidence tending to prove that that was potentially the defendant's phone. Let's say there was a text message from 5 days before the time period that said, hey, this is John Doe. Not only is it evidence of the crime being committed, but also whose phone it was and who might have been sending the messages and had access to the other content on that phone is, evidence of ownership, possession, custody, control. That's clear purview for any search warrant, not just for a cell phone.
And what's your view on the notice issue? I think there are, I know that your view is that you didn't have adequate notice of this issue, but in the event that the court is going to allow the defense to make the argument about the misrepresentation and allow Gorecki, and I haven't made a decision about that yet. I think there are a couple of ways to deal with this. One is the expert is here, we could hear the expert, and then I'll ask you the same question, Attorney Smith. And then we would need to come back, obviously, to allow you to present evidence to counter that if you wish to do so. The other option is that we, the defendant has, clearly asserted that he wants to go to trial in November. Attorney Smith, as you know, there was a challenge finding a date. We cleared a day so we could do it all today. So I'm a little dismayed that that the defense acknowledges that there is, the argument that's made is the Four Corners argument, and that this goes outside that Four Corners argument. You're shaking your head, but you just said to me that you do intend to pursue that misrepresentation argument.
Okay, so I have both arguments. I said that I was presenting him for the Four Corners argument, where the state relies on common knowledge or assumption, and I have found it on paragraph 12 in justifying why they could go outside of the 4 days, talking about fair assumption that a majority of people would delete some data from their phone, and that's the need to expand the search. He is going to talk about those four corners and the foundation for probable cause to go outside the 4 days that they need.
Okay, so I'm going to stop you right there. Okay, what's your view of whether or not Gorecki can testify just to that?
You don't get to. There's no established case law, and I'll note defense isn't citing to any. There's no established case law that allows the defendant to call a witness to challenge a search warrant affidavit unless it gets to that level of a material misrepresentation. That was knowing or reckless.
State versus Page was not about a material misrepresentation. The state called an expert to explain to the trial court why the search needed to be expanded beyond particular photographs and go through all the photographs that were in the phone. And I am doing the same to say they don't need to for all of the information that they collected here.
Okay. So what I'm going to do is, I think we can begin this because I'm going to take these arguments under advisement for the moment. I think we've got some time because the state's going to present its case. I don't think that my not ruling on this, and this came up pretty quickly, so I did want to hear from the defense on this, but it sounds like they're sticking with their Four Corners arguments, and the question is, do they get to present a witness on that? That's a little different than what I was looking at previously, so I want to give that some thought. I don't see any reason why we can't proceed on the motions to suppress at this time, and I'll, at a break, I'll consider it further. and consider what I want to do about that. Do you have any objection to that?
Well, I do just want to address the court's question posed to the state earlier
Yes.
about the notice issue. If Mr. Gurecki is allowed to testify today, the state would be at an extreme disadvantage due to the late disclosure. Everybody knows what happens when there's expert witnesses. Both sides get a chance to depose the expert, get a transcript, potentially consult with an opposing expert, so to speak. We are not prepared, based on when this expert was disclosed, we are not prepared to effectively cross-examine. We could do something, but speaking as a litigator, as a trial attorney, part of the effective cross-examination of an expert comes from what's elicited in deposition and comes from what an opposing expert may say. And the state hasn't had the opportunity to do that. So the state would not be in agreement with Mr. Gurecki testifying today at all.
Okay, thank you. All right, so I am going to consider that. Do you still agree that we proceed not knowing whether or not he's going to testify at this juncture?
Of course.
Okay, very good. And any objection from you, Attorney Smith?
Not to proceeding, no, and I would put on the record that I did comply with the rules for the expert disclosure for a hearing.
Okay. So, I'll take that into consideration as well. But I think we can go ahead and proceed. You may call your first witness.
We can. There is one evidentiary issue we'd like to approach on.
Yes.
Oh, yeah.
Would you like the state to swear the witness?
You may swear the witness.
Could you raise your right hand? Do you swear the testimony that you're about to give will be the truth under the pains and penalties of perjury?
I do.
Good morning.
Good morning.
Could you please state your name and spell your first and last name for the record?
Sure, John Dunleavy, John. The last name is Dunleavy,
How are you employed?
with the Manchester Police Department
How long have you been employed with the Manchester Police Department?
since November of 2015.
And what is your current role within the Manchester Police Department?
I'm an investigator for the Juvenile Division.
And how about your title?
I'm currently a chase investigator who investigates crimes against children.
Are you a detective?
I am.
With respect to the case of Harmony Montgomery, what is your role with that case?
The lead investigator.
When did your involvement with that case begin?
On December 28th of 2021.
At that time, it was a case of a missing 7-year-old child, correct?
That's right.
And in those first days, what did you learn about who should have had custody of Harmony?
Adam Montgomery.
What did you understand was Adam Montgomery's relationship to Harmony Montgomery?
It was her father.
Were Adam's whereabouts known initially?
Initially, we believed he might have been in Maine with a current girlfriend.
Anything more specific than that?
No, just that he was with a girlfriend up in Maine.
During those first few days of the investigation, so I'm referring now to the kind of last couple days of December of 2021, did you speak with anyone else in order to learn more about the situation?
I did,
Was one of those people Kayla Montgomery?
yes.
What did you understand Kayla's relationship with Adam to be?
It was his current wife.
And it was your understanding that marriage went back at least as far as 2019?
Correct.
When was it that you first spoke to Kayla Montgomery?
On December 28th of 2021.
What did you understand Kayla's relationship with Harmony Montgomery to be?
I was her stepmother.
Not her biological mother?
Correct.
On December 28th of 2021, did Kayla give you any information about Harmony's whereabouts?
She did.
And what was that?
She stated in November, December of 2019, she had been dropped off at work, and from there, Adam had brought Harmony back to her mother in Massachusetts.
I just want to clarify some of the pronouns you used. When you said she had been dropped off at work, who are you referring to?
Kayla.
And then when you said her mother's in Massachusetts, who were you referring to, her mother?
Harmony's mother.
Did you learn who Harmony's mother was?
I did.
Who's that?
Crystal Sorey.
And in those, again, last few days of December, did you speak with Miss Sorey?
I did.
When was that?
December 30th of 2021.
When did Miss Sorey say was the last time that she saw Harmony?
Via FaceTime around Easter of 2019.
And that would have been months before November or December of 2019, correct?
That's correct.
When you spoke with Miss Sorey on December 30th, did you tell her what Kayla had said about Adam returning Harmony to Miss Sorey?
I did.
How did Miss Sorey react?
Reasonably upset. She was crying when I told her.
Can you just explain what you mean by reasonably?
She acted appropriately, like it was an appropriate response to her learning that the father of Harmony did not claim to have custody of her.
So during this time, again, the last few days of December of 21, were efforts being made to get a more specific location for Adam Montgomery?
Yes,
Was he eventually located?
he was.
When was that?
December 31st of 2021.
And approximately what time of day?
My first involvement of seeing him was around 9 o'clock in the morning.
And is it your understanding that's approximately when he was first located?
Yes, roughly around then.
What was the location where Mr. Montgomery was first located?
Wolf Park, which is on Harvell Street in Manchester.
Were you the officer who first found him there?
No,
But at some point, you went to speak with him?
that's right.
When you went to Wolf Park to speak with Mr. Montgomery, was anybody else with you?
Yes, Detective Riley and Detective Coswick of the Juvenile Unit in Manchester.
And on that morning, did you in fact speak with Mr. Montgomery?
I did.
Do you see him in the courtroom today?
I do.
Could you just indicate where he's seated and identify an article of clothing he's wearing?
He's sitting to your right in the orange jumpsuit.
Could the record reflect identification of the defendant?
It so reflects.
So you said you weren't the one to actually find him in Wolf Park, correct?
That's right.
Based on your understanding, though, what was the defendant doing when he was found there?
He was sleeping in a vehicle.
Was it your understanding that he was basically living out of that vehicle?
Yes.
When you got there, who else was with the defendant?
His current girlfriend at the time, Kelsey Small?
Was Harmony there?
No.
Was there any indication that you could see or that you were made aware of that morning that Harmony was with them?
No.
Did the defendant at that time indicate whether or not he was willing to speak with you?
Yes, he indicated he was not going to speak with me.
He said that pretty repeatedly, correct?
That's right.
Despite that, did you continue to ask him about Harmony's location?
I did.
Why?
Because I was trying to understand if his daughter, who was 5 at the time when she was last seen, was safe with family, with friends, her current whereabouts.
You had earlier described Miss Sori as being, you said, reasonably upset when you told her that Kayla said Harmony was supposed to be with her. What was the defendant's reaction when you asked him about Harmony?
There was no emotion. There was no questions, no follow-up questions, no assistance given to try to help us.
Did he cry or appear to get emotional at all?
Absolutely not.
Did you ask him where Harmony was?
I did.
And at first, did he tell you where she was?
No.
So, Detective, I'd like to show you a small clip of that interaction. There were multiple officers there with body-worn cameras on, correct?
That's right.
One of those was Officer Stanzel.
That's correct, yes.
And for the record, Officer Stanzel's body-worn camera of that morning is Defense Exhibit B.
Your Honor,
Yes.
while I don't object to this line of questioning nor the admission of the portion of the tape, because I'll bring it in as well, I would remind the court that this is the interaction where the statements were suppressed. I think they go to Detective Dunleavy's actions and understandings and totality of the circumstance, so I'm not waiving the issues about suppression that have already been granted.
And that's my understanding as well. The court granted the motion to suppress these statements, but the purpose of these questions is basically the morning interaction with the defendant influenced Detective Dunleavy's mindset in the afternoon interaction with the defendant. So this testimony is basically going to what was going on during that morning interaction.
Okay.
Can I move your thing over?
Sure.
Witness? Yeah. Thanks.
So can I confirm with the monitor? I just hit the present button.
Yep.
I don't need to hit follow,
You just need to follow this, yes.
but
It
there's,
should show up.
it'll show up.
Yep, there should be a follow.
So I don't have to do anything?
So-
You need to follow as well.
Do I have to hit something?
Yep.
But not until after he starts to present, right?
We need to, no, we need to do it before you present.
I see the follow.
Just have her click that. So you just hit present and then follow presenter. Okay, got it. Okay.
Do I need, and then I need to click on his name? Yes, okay, very good. Thank you. Thank you.
Okay, thank you. All right.
All set,
I think so.
all set, Attorney Smith?
I think so.
Okay. Let us know when you anticipate that it's starting.
I will.
Okay,
So,
thank you.
and for the record, this is again Defense Exhibit B, and I'll be starting it at 12:39 into the recording.
And can you just make sure that the witnesses,
So I'm going to be hitting the play button now.
What do I do? It's not going.
right, I'm going to stop you a moment.
I paused it.
Okay, thank you. I think he has audio. I don't have audio coming through mine.
It should only be playing out of the one.
It'll only be playing? Okay, so we'll need to increase that audio. Thank you. These are new systems, everyone, so we're working our way through. So thanks to IT for being here.
And I'll note for the court, for IT, that the sound in this portion is kind of muted because the camera is kind of back from the two who are speaking, so it will need to be turned up probably to max. Can I just confirm that it at least played for everybody, though? That everybody saw the video movie?
Yes.
I think.
So I'm restarting now from 12:39.
Mine is not moved. Okay. Why?
This,
Isn't this
Did you-
being
It's only
presented
supposed
to
to play out
everybody?
of
what?
the one up here.
It's only supposed to play out of the one up here, I guess, so that
I-
everybody hears it and so that we're not hearing feedback from other people's.
Oh,
Uh,
okay. So I knew.
Magnify it.
So,
Okay.
try again.
Okay.
Starting
Well,
from the beginning, if you would.
I will, but while we have it here, just because this is visual only.
Okay.
So for the record, we're paused at 12:50 in the timestamp. Can you see the people in the video, Detective Dunleavy?
I can, yes.
So one of the individuals kind of has its back turned to the camera and has what looks to be a dark-colored hoodie with the hood up. Do you see the person I'm referring to?
I do.
Can you identify who that is?
Mr. Montgomery.
And then there's another person, looks like a police officer with a badge, who's kind of on the other side of the car from Mr. Montgomery, facing the camera. Can you identify who that person is?
Myself? Or are you talking about, or the person
I'm
behind
talking
me?
about you. Is that
Okay,
you?
all right, yeah.
Okay. All right, I'm going to go back to 12:39 then. I'm going to play from here.
Hey, what's going on? What? Oh, wait. Am I in the rush? No, you're not. You don't have any warrants here. All right, I got nothing to say. Adam, right? Montgomery. Yeah. Do you remember me from the Elliott Hospital from a while back, man? Yeah, I got nothing to say. Right. So, hey, man, the only thing we're trying to figure out is where harm is, okay? Okay. So, the concern is that you guys are the same, right? Okay. You're not in trouble. Nobody said you're losing your daughter, okay? So I want to make that clear. So, I have my body tomorrow, so just like everybody else is being on to do. So you just need to find out where she is. That's all I'm concerned about. You're not in any trouble right now that I know of. Okay. You have no warrants. Okay. So,
Mr. O'Neill, I'm going to ask you to
where's
stop
your daughter
for a
so we
minute.
can check on her and make sure that she's okay? Right now, I have nothing to say to you guys. But that's not what I'm.
Can you stop
I'm
it?
just asking where she is. I have nothing to say.
Oh, the delay. Okay, thank you. So, you all have heard this before. So, I can't hear it clearly or loud enough. So is this the best we can do? Okay. So of course, the court will have these. They've been entered as full exhibits, so I will listen to them, but it is a bit problematic. Yes?
I'm just wondering if it can play for you rather than Detective Dunleavy, because it really is a full exhibit being presented to you in a sense. And Detective Dunleavy can probably listen to yours and answer any question posed.
I also brought a separate speaker, which I could hook up to my own computer that may be able to amplify the sound a bit more.
Okay. I do think there's going to be a lot of videos here. We need to get this right.
If the court can just bear with me for a moment.
Yes, thank you. But is that loud enough to do the whole, so that the witness and I can both hear?
I can't with them. Okay, let's see how long that takes them. How many people in New Hampshire does it take to get audio? Look at Miss Gingy.
Roberta,
I can't with that. Oh shoot! I better pause that. Let's see. Ew, he looks really, really rough and scary. Ugh. Some people just should not be allowed to have kids. Kids, rather. How dare he smile and laugh? Oh, I just want to smack him. Smack. Okay, it looks like they finally do get it running here. Let's see.
Paused it because I didn't want to hear what was going on.
Oh my God, the camera.
So, am I just hitting play now on mine? No. I'm still following presenter.
Roberta.
Oh, the pause, yeah. It says already following.
This
I have
guy's
it on
like,
pause.
I only
Click
plan
that.
to be here for a little
Okay.
bit today. Oh my God, we're muted again. And we're muted.
So,
All right,
is
guys.
it showing 12:39? Because I just confirmed.
I don't know if
Mine
we're
is
back,
showing
but
12:39.
we'll see.
I'm in interrogation room at 12:39.
Is that?
That's not the right video.
That's what, I have what Shannon has.
I have the post arrest.
Roberta,
I do not.
That's not what I'm presenting. I'm presenting the defense exhibit B.
Can I just go there and have it done?
What is she
Stop
talking
it.
about? Go where?
So I'm gonna stop it all. It's gonna kill.
Cut his mic. It's cut his mic.
Okay.
Unleash the lawyers.
Okay. I just stopped it and restarted it. Yeah, that's not the right one.
I am Margot. I just don't know when yet, but I will be doing Taylor Parker.
Where's that?
And we're muted again.
Roly-poly, daddy's little Betty. Betty's gonna be a man someday.
His face. His face.
Sure.
Thrown out Twitters.
I know, Rex. I don't know if I have backups of the sounds, but some of them are actually on here, but I didn't delete all of them, I guess. I'm just pushing buttons and seeing like which ones
Chris and Roberta
which ones work.
thrown out Twitters.
God almighty.
That's him right now. Mood.
God almighty.
Who's Patsy?
Do you want them to go to Walmart and hang up a sign?
This poor guy.
Whereas previously I had been starting at 12:39.
Okay,
The
here we
timestamp
go.
Controls are too finicky, and the best I can do now
Hopefully.
is 12:38. So at this point, I'll be starting.
Hey,
before
Scott
12:38.
H.
And this is again Defendant Exhibit B.
Hey, man, what's going on? What? How are you? Am I under arrest? No, you're not. You don't even want to. All right, I got nothing to say.
So I'm going to pause it there, Detective, and have you re-identify the people in the video.
All
Again,
that
there's
for that one little clip.
standing on the camera side of a vehicle with what looks like a dark-colored hoodie with the hood up. Who is that?
Mr. Montgomery?
The defendant?
Yes.
And then there's another individual walking towards the vehicle, but still on the other side of the vehicle, carrying something in his hand, maybe shortcut hair, looks like you. Who is that?
That's me.
And the two people that we can hear speaking, who are those people speaking?
Him and I.
And he's the one who asked if he was under arrest?
Correct.
And you're the other voice?
Correct.
Got nothing to say. Adam, right? I don't. Do you remember me from the Elliott Hospital from a while back, man? Yeah, I got nothing to say. Right. So, hey, man, the only thing we're trying to figure out is where my money, okay? Okay. So, the concern is that you guys are sick, right? You're not in trouble. Nobody said you're losing your daughter, okay? So I want to make that clear. Just want to let you know I have my body can monitor, just like everybody else is being on you. So you just need to find out where she is. That's all I'm concerned about. You're not in any trouble right now that I know of. Okay. You have no warrants. Okay. So, where's your daughter so we can check on her to make sure that she's okay? Right now, I have nothing to say to you guys. But that's not what I'm just asking where she is. I have nothing to say.
So I'm stopping for the record at 13:30 on Defendant Exhibit B. Does this clip that we viewed fairly capture the defendant's reaction when you first told him that his daughter Harmony was missing and you were looking for her?
Yes.
You continued to speak with the defendant after this clip that we viewed, correct?
Correct.
During your further conversation with the defendant that morning, did anything about whether he had a cell phone come up?
Yes.
What did he say about whether he had a cell phone?
He said he had lost it.
You mentioned before the break that that morning he was with a woman named Kelsey Small.
That's correct.
Did he say anything about whether Miss Small had a cell phone?
Yes, she had broken hers or it had fallen in the toilet.
You spent about 40 minutes there before ending the interaction, correct?
Yes.
By the end of that encounter, had the defendant said anything about where Harmony was?
Yes.
What had he said?
He stated around Thanksgiving time of 2019 that Harmony's mother, Crystal, had come up to the man.
Your Honor, we're sort of getting into substance of something that's been suppressed.
So again, this goes to the defendant's state of mind. The state is going to argue specific legal standards about the interaction in the afternoon, and what the state is eliciting right now is basically a conflict between what Kayla Montgomery said, what Crystal Sorey said, and now what the defendant said. So that would be all things that were playing into the detective's state of mind when he made later decisions on the afternoon of the 31st.
Welcome, Margot Moore.
Attorney Smith, anything further?
No, nothing further.
Overruled. You may proceed.
Let me re-ask the question, Detective. By the end of that encounter on the morning of December 31st, what had the defendant said about where Harmony was?
He stated that Crystal Sorey had come up to Manchester sometime around Thanksgiving of 2019, taken custody of Harmony, and that was the last he had seen of her.
During this encounter, the morning of December 31st at Wolf Park, did you speak with Miss Small?
I did.
And did you ask her about whether she had a cell phone?
I did.
What did she say?
She said she had dropped it in a toilet.
And did she say anything about whether the defendant had a cell phone?
Yeah, she said he had lost it.
Later that day, so now talking about the afternoon of December 31st of 21, did you see the defendant again?
I did.
Where was that?
It was in the area of Union Street and Lake Ave in Manchester.
And about what time did you see him there?
Approximately 4 p.m.
What were the circumstances of that interaction?
JB,
Myself and Detective Riley had to serve him with an ex parte order through the courts.
And in general, what was the
JB?
What did that ex parte order?
You have to stand down. You have to stand down.
That he give us the location of Harmony and/or relinquish custody.
Did the order include anything specific that the defendant was supposed to do with the Manchester Police Department regarding Harmony?
Cooperate in answering those two questions.
And when you say those two questions, what do you mean?
Relinquish custody and/or disclose the location of her.
That afternoon of December 31st, Were you the first officer to encounter the defendant?
I was not.
There were other officers there when you arrived?
Correct.
And you mentioned another officer who accompanied you specifically, correct?
That's right.
Who was that?
That was Detective Riley.
While you were at that area of Union Street and Lake Ave in Manchester, were you given anything that had been taken from the defendant?
Yes, a cell phone.
Who gave that cell phone to you?
Officer Martins.
Roberta.
So I'd like to present now a couple of videos of the interaction with the defendant, both before you arrived as well as once you were on scene. So for the record, the first video is going to be State's Exhibit 7, which is body-worn camera of Officer Zachary Lupaka. I just presented the video.
Roberta. For me, let me refresh and see if it comes up that way.
You have to refollow.
I'm sorry, should I have not have stopped the previous presentation? Oh, okay. Okay, I apologize.
Okay, I have it now, thank you.
Defense.
I just there it goes.
Everybody should see a steering wheel with a person's hand on it. Okay. So I intend to play this video in its almost its entirety, but starting right from the timestamp of 00.
JB, we have to stand down.
And I'll note for the record, the beginning part of the video does not have sound. It should come on momentarily.
In one of the pockets, by the other pocket, I'm not sure. All right, just relax. What's going on, house?
Not yet, no.
I'm being cuffed? I'm being cuffed? For what? Being detained. For what reason? Give me a second, all right?
I'm pausing it at the 55-second timestamp. Detective, you can see a subject kind of right in front of the camera with the words Ralph Lauren. Do you see what I'm referring to?
I do.
Based on what you've heard so far and what you've seen in this interaction, are you able to identify who that is?
Yes, it's Mr. Montgomery.
The defendant?
Yes.
And from what you've seen so far, the person wearing the camera, from what you've seen so far, can you tell what they're doing with respect to Mr. Montgomery?
Performing a pat frisk.
Is everybody okay with the way the video's playing and with the sound?
Thank you.
So resuming from 55 seconds.
Did I smoke a cigarette here before? Can you give me a second?
Thanks, look at what's in your hand for me, please.
Yep.
Thank you.
Do you mind if I just check your pockets, man? No, go ahead, buddy.
If I can ask Detective if you're able to identify the speakers. We just heard somebody say, do you mind if I just check your pockets, man? Can you tell whose voice that is?
That's Officer Lupaka.
You know Officer Lupaka?
I do.
You've interacted with him?
Yes.
And then there was a person who in response basically agreed to that. Did you recognize that voice?
Yes.
Whose was that?
Adam Montgomery.
So that was paused at 117, resuming from that point.
And then you got a lighter on you? Don't?
You got a lighter on you? You got a lighter on you? No?
If I get some little light, I'll let you smoke, right?
What's going on, guys?
I'll explain it to you in a second, right, bro?
I'm being arrested. Let's go figure it out.
Hey, beer. Yeah, that's nothing. Yeah. Just hold still, I see it, just hold still. Yeah, no problem. Okay.
So pausing at 2:10, unfortunately it's blurred where I paused it, but have you been watching the video as it's been playing?
Yes.
In the sort of the middle to bottom third of the pause screen, there's kind of a darker blurry object. Do you see the darker blurry object I'm referring to?
I do.
Were you able to more clearly see that object before I paused the video?
I did.
What was that object?
Cell phone.
Resuming from 2:10?
Yeah, all right, that's fine. So detectives want to speak with you? Will you be detained at this point? All right, but,
not arrested.
okay, but they already spoke with me this morning. You're being detained? They already spoke with me. I'm sorry.
Detectives are inbound your location.
I gotta.
You're being detained so they can serve you some paperwork at this point.
That's fine, but I gotta be in custody?
Well, initially they stopped you, they just, for safety, right, that's what the detainment part is. Once they determine you're safe, I'll
No problem, yeah.
So you said you had a needle on you?
I did.
Stuff like that with weapons, like we just got to be extra careful.
No, I get that, I understand that, but... No, trust me, guys, I get that 100%. But this is a little excessive. Come on, I don't have nothing on me, but I've been cooperative with you guys. I will tell you, yeah.
Spread your feet? Yep.
Give me 1 second. Yep. Just chill, all right? Yeah, no problem. I'll help you.
Pause the video at 4:05. Detective, at this point in the interaction, it looks like Officer Lupaka is walking away, correct?
Correct.
Based on your understanding, did the interaction with the defendant continue out after Officer Lupaka walked away here?
It did.
So the next exhibit I'd like to present to the court is State's Exhibit 1, which is body-worn camera from Officer Austin Beering. Did that load correctly for everyone?
Yes.
Yes, sorry.
So starting from the 00 point on the video.
For what reason?
So pause it at the 20-second mark. Detective, do you recognize the person in the middle and the person to the right on the screen right now?
I do.
Who's the person on the right?
That's Officer Lupaka.
And the person in the middle with the dark-colored hoodie with the hood that appears to be up?
Adam Montgomery.
Fair to say that this beginning part of State's Exhibit 1 basically overlaps with at least some of State's Exhibit 7 that we were watching previously?
Correct.
Continuing from the 20-second mark.
We'll get that to you in a second.
Did I smoke a cigarette here before? Give me a second. And what's in your hand, please? Yep. Thank you. Do you mind if I just check your pockets then? No, go ahead, buddy.
I paused at the 45-second mark. Could I perhaps just make one adjustment on the speaker that might make the sound a little less cloudy?
Sure.
resuming from the 45-second one.
Hey man, you got a lighter on you? You don't? Bro, you got a lighter on you? You got a lighter on you? No? Alright. If I get someone with a lighter, I'll get you a smoke, right? There's no lighter right there on the ground. I'll explain it to you in a second, right, bro? I'm being arrested. We'll figure that out right now,
Hey, beer.
Pausing at the 118 mark, Detective, there's an officer now who's in the middle, slightly to the right of the screen, dressed in black. Do you see who I'm referring to?
Yes.
Who is that?
Officer Martins.
Resuming from 118.
Hey, beer. My car out of the road. I got you.
Alright, they tell you being audio visually recorded?
Yeah.
Alright, man. Some detectives want to speak with you. You're just being detained at this point.
All right,
I'm not arresting you.
Okay, they already spoke with me this morning.
You're being detained.
Being detained, like, they already spoke with me.
I'm just telling you, you're being detained right now. So go ahead.
Go there again.
Detectives are inbound your location.
I gotta.
You're being detained so they can check if you pay for it.
That's fine, but I gotta be in custody.
Well, initially they stop you, they just grab for safety, right? That's what the detainment part is. Once they determine you're safe, I'll.
No problem.
So you said you had a needle on you?
I did.
Stuff like that with weapons, like, you just gotta be extra careful.
No, I get that, I understand that, but, no, trust me, guys, I get that 100%. But, it's a little excessive. Come on, I don't have nothing on me, but I've been cooperative with you guys, I would tell you, yeah.
Spread your feet. Yep.
No, it's an, I want to play anything on the thing. It's the element. It's not checked out. Yeah, so it's something they just had to do with DCYF. Yeah, I don't know.
Well,
Yeah, we'll probably pull on.
yeah, sorry, I'll just tell you. They made a selling a roll call we were needing for it. Yeah, so I think miscommunication from.
I know you guys are doing your dog and shit, like, I'm really not being aggressive or anything, but like, this is a little excessive.
No, just grab your stuff on. We'll get you off now, it should be all fucking back, and that's been out here with you. Let me see that needle real quick. Yeah. I just don't want to break it open. I'll put it right here next to, right here.
All right.
You can actually come stand over here.
It's all right, I don't think you're doing enough space.
So we're just gonna hang with you till they can get out here and explain to you the paperwork.
All right, so can I ask you a question like that?
You can ask them right from the horse's mouth too when they get here. I think that same detective that talked to you this morning is gonna be the one that comes here.
All right.
To speak with you.
Yep.
You do this, I'm gonna hang here for a second until they get in, but then
You're taking on this. No, I'm working.
Yeah.
No, this is the yeah.
I don't know you let it, you like.
Just
shadow.
I'm gonna, yeah, so I think it's detective that would be coming.
Well, they post had a roll call.
Thank you,
That is
John.
for a takedown right now.
Yeah, John did it.
Yeah. So I was like walking the phone call. Go. And so I hear you guys breaking. I'm like, fuck, we're late. So we all were late. So I'm like trying to catch up to you guys and like get back off.
Oh, that was you guys?
Oh,
They're yelling at me.
sorry. I got you yelled at.
It's all right.
Not a little overboard, all you guys, like, I'm just, no.
What's that?
Oh, the same it's not overboard, like all the police, but like one person, I was
No, it looks like a lot. A lot of these cars are two-man cars. Right. So each car, you know, there might be 3 or 4 cars here, but two men per car. So they ride together, we ride together. So we only count as one, half a person each. I'll get on your shoulders, so maybe one full person. Works in trench coat. Do like the old movie theater trick.
I'm gonna get to grab my hat. You should. You should need it. Hey, take your phone. You have a cell phone on you? Yeah, I'm just gonna I'm gonna have him hold it for a second just till the detective gets here. This might be being, did you call, so this is all about this is about the thing.
You're on channel 5.
What's this red light? Is it dying or?
Yeah, it's dying.
Oh, okay.
And that's not my phone.
It's not?
Oh, it's not yours, you're just using it? Who's it? It's my friend.
Your friend? Who's your friend?
Okay, I'll let him talk to you about that. I mean, this is his thing or whatever, I'll let him talk to you about it. Just give me 2 minutes. Bear with him, but he'll give you all the fucking. You know what I mean?
I'm pausing at 6:55 in the video. That last interaction about the phone was captured from a slightly better angle, so I'd like to play for the court that same last interaction with the phone, but from a different angle. This would be from the body-worn camera of Officer Martins, which is State's Exhibit 8. And I'll be playing State's Exhibit 8 from 4:55, so that should be queued up for everyone. Beginning at 4:55.
Yeah, he did. You did it? Hey, get your phone.
Do you have a cell phone on you? Alright, I'm just gonna I'm gonna have him hold it for a second just till the detective gets here. This might be being, did you call, so this is all about your dog, right? This is about the thing you talked about your dog.
You're on channel 5. What's this red light? Is it dying or?
Yeah, it's dying.
Oh, okay.
And that's not my phone.
It's not?
Oh, it's not yours, you're just using it? Whose is it? It's my friend. Your friend? Who's your friend? Okay, I'll let him talk to you about that. I mean, this is his thing or whatever, I'll let him talk to you about it. Just give me 2 minutes. He'll give you all the fucking.
You're making him angry.
Grim?
Yeah, look at this. It wasn't barking.
Pausing there at 5:50 in State's Exhibit 8. So, Detective, did you just see in the video the interaction of one person taking the phone from the defendant and giving it to another phone?
Yes.
Another person?
Yes.
The person who first takes the phone from the defendant, who was that, if you know?
That's Detective Papalardo,
And then he gives it to whom?
Officer Martins.
So what I'd like to do now for the court is return to State's Exhibit 1, the body-worn camera of Officer Beery, and resume that from 6:55 where I had previously stopped, and play that for approximately another 4.5 minutes to the end of the interaction. So queued up for everyone should be State's Exhibit 1 at 6:55. Playing from that point.
Right up.
What you need, pal? Oh, let's see where it went. He was on the phone and said he. Yeah, he's still all right back.
How's the ball doing? Where'd it go? You hear him? Never. Riley? Scott Riley, yeah. I've never met him. I've only been here like 3 times as long as you. No big deal. But I've never even crossed paths with him. Big deal. Sure, yeah. Back. Hold.
So pausing the exhibit at 9:30. So there's basically 3 people that you can see in frame here, Detective?
Correct.
The one all the way to the right that looks like you, who is that?
That's me.
And then the one to the left, right next to the letter LICE in the police vehicle there, who's that?
Detective Riley.
And then the third individual looks like, back to the camera, maybe a ball cap on with a dark colored hoodie.
Adam Montgomery.
We zoom in here from the 9:30 mark.
Yeah, that's right on this. But have you worked with it? Have you ever? Yeah. What's up? Yeah. Here comes Scotty Trudeau.
So that's paperwork that's saying you gotta keep on custody and get arm handles. No, it's being served. So you have to produce for all that. Okay, sorry. You know how to get a hold of me if you decide to do that kind of conversation with me. But you know, you right there. But I don't want to be home. It's not going away. You may have to come back real quick. That'd be good if we get on the side of it. Going on this road before. You know, I don't want to here. You're free to go. Good.
And that video ends at a timestamp of 11:41. Detective, at the end of that video, did you see the defendant walk away with some papers?
I did.
Was that the order that you and Detective Riley had gone there to serve him with?
Yes.
You also had a body-worn camera on during this interaction, correct?
Correct.
Was your camera working as you expected at that time?
It wasn't.
What, can you explain that?
So I wasn't sure of the issue at the time. The body cam can be activated through a watch, which requires a signal. So if the battery is low on the watch, it might not properly start it on time, or if the connection between the watch and the body cam is off, it could cause an issue. So I think that was what was going on at the time. So it started a little bit later than I had initially attempted to have it start at.
Did you, at the time, even realize that your camera had started?
I hadn't known, no.
So during this interaction, you believed your camera was off, basically?
Correct.
So I'd like to watch the portion of your body-worn camera footage with the defendant that it did capture. This is State's Exhibit 9, and I'll be playing the first minute of State's Exhibit 9. Can I confirm everybody sees State's Exhibit 9? Playing from the 00 timestamp.
So that's paperwork that's saying you gotta give up custody of your kid? Harmony.
I have to sign this.
No, just being served it. So you're gonna have to produce where all that, where your daughter's at. We're gonna be taking your phone.
It's not my phone.
Okay, but it's ours now. So, you know how to get a hold of me if you decide you want to come down and have a conversation with me. But I think you need to do the right thing and kind of have more of a conversation with me. So we're gonna figure this out one way or another. It's not going away. It's gonna get really fucking big real quick, and it's not gonna be good if you get on the wrong side of it. You know what I mean? So we've gone down this road before.
Yep.
You know how to get a hold of me, all right? You're free to go. I'll take that. Yeah. Thanks.
Stopping at the 1 minute mark. So at the end there, you're handed something, correct?
Correct.
What is that you're handed?
Cell phone.
And who handed it to you?
Officer Martins.
And is it your understanding that that phone was the phone that the defendant had on him that afternoon when he was stopped?
Yes,
Did you eventually give that phone an evidence number?
I did.
What evidence number did you give it?
It was labeled JD-15.
Why did you take that phone on the afternoon of December 31st?
It was kind of a combination of things. The interaction in the morning, when he had stated to me he had nothing else to say in regards to his daughter missing, and then eventually he had stated to me that the mother had come up to take custody of Harmony, knowing that Crystal had indicated otherwise, that she had never gotten custody of Harmony. And then that morning also they indicated that neither of them had cell phones, and now hours later he has a cell phone. He's indicating to me it's not his cell phone. A minute or so later I spoke to Kelsey Small. She indicated it was his cell phone. And then right after this interaction ended, he was seen having communication with Kayla Montgomery, which heightened my reason for suspicion and reason for me to eventually get a search warrant for that cell phone.
When you took the phone, what we just saw there at the end of that clip, did you think that that phone could have evidence of a crime?
I did.
Why did you think that?
There was a domestic violence case between Adam and Kayla Montgomery. There was a court order by conviction that prohibited them from having contact with each other, which dated to early 2021. I had learned after this interaction that they had been seen communicating, and then after my interaction with him, where he's walking away in this video, he is seen speaking with Kayla Montgomery by myself and Detective Riley.
You didn't apply for a search warrant for that phone right away, correct?
Correct.
In fact, technically, you yourself never applied for a search warrant. It was eventually Detective Valenti who applied for the search warrant, correct?
That's right.
Why the delay in applying for the search warrant?
At that point in time, we were working 70 and 80-hour weeks trying to find this little girl. It was very hectic at that time. So certain things become priority. Our main priority was finding her safely, so the cell phone didn't become an initial object that we applied for a search warrant at that time due to the hectic nature of the case to start off.
Did you ever receive additional information regarding that phone that was taken on the afternoon of the 31st from the defendant, regarding whose phone that might be?
Did.
What was that additional information?
We had intercepted a letter from Kayla Montgomery that she had sent out through the Hillsborough County Department of Corrections to a friend of hers. In the phone, in the letter, she had indicated that she had a Blue View 3 track phone, which was taken by the police, which matched the phone that we had taken that day from Adam Montgomery.
Were there any other Blue View 3 phones seized up to that point in the investigation?
No.
Just the one on the afternoon of December 31st from the defendant?
Just that one.
Shortly after receiving that information, then, Detective Valenti applied for the search warrant for the phone?
Correct.
So why, at that point, get the search warrant?
We had established that there had been discrepancies, obviously, between the ownership. At that point, we understood that the phone belonged to Kayla Montgomery. They would have had to have interaction between each other to exchange that cell phone, which would have gone against that court order by conviction that they had still currently in place.
Have you had occasion at any point to review the search warrant affidavit and application that Detective Valenti submitted for that phone?
I did.
So I'd like to have you review Detective State's Exhibit 4. I'm going to pause my presentation, which I believe should let you use the touch screen to scroll through it on your own. Can you confirm that you're able to do that?
Yes.
Can you just scroll through that on your own and let me know if you recognize what State's Exhibit 4 is?
That would be the search warrant and affidavit for the cell phone that Detective Valenti typed.
And it includes, I'm resuming control over the presentation, includes the application at the beginning, correct?
Correct.
Then moves into the search warrant itself, correct?
Yes.
And then from there continues with the attachments and the actual probable cause statement?
That's right.
Now I'd like to jump ahead in the timeline to January 4th of 2022. Well, let me just back up to the search warrant. State's Exhibit 4, again, has the signed search warrant from Judge Edward Tenney, correct?
Yes.
After receiving that search warrant, was JD-15, the phone taken from the defendant on December 31st, searched?
It was.
So now I'd like to jump ahead to January 4th of 2022. That's the night the defendant was arrested, correct?
Yes.
And after his arrest, did he agree to be interviewed?
He did.
Did you conduct that interview?
I did.
With who else?
Detective Riley.
The same Detective Riley that we saw accompany you to serve the court order?
Yes.
Where did that interview with the defendant on January 4th take place?
It took place at the Manchester Police Department in one of the interview rooms in the detective division.
And was that interview audio and video recorded?
Yes.
At the beginning of the interview, did you go through the defendant's Miranda rights with him?
I did.
And was that captured on the video?
It was.
So I'd like to play that portion of the video. For the record, this is State's Exhibit 5. If I can just confirm that's loaded correctly for everyone. So playing from the 00 timestamp on State's Exhibit 5.
Brett, we might be able to work on that in a few. We just turned this on. This is already on video recorded. You all right with that? Nope. Okay.
Pausing at the 8-second mark before continuing. You see 3 people in the video?
That's right.
The one furthest to the right, who is that?
Adam Montgomery.
The one sort of to the left and up, who is that?
Detective Riley.
And the one kind of in the center and down, who is that?
That's myself.
Playing from the 8-second mark.
We'll do our best to try to get you the cigarette. Yeah, we got cigarettes somewhere, so try to work on that, okay? Before we have any conversations, I'm just going to have you read something, okay? And then we'll just go from there. just so you know, because you're under arrest right now, I have to read you this stuff, or you have to read it to me. Again, Detective Riley, Detective Dunleavy. It's January 4th, 2022. It's 8:55 p.m. You can read and write English, correct? Okay. So, Adam, I'm going to have you start from there where it says I, and then I'm just going to have you read down.
I, Adam Montgomery, have the right to remain silent.
Start from here. I, Adam Montgomery,
give the following voluntary statement. Detective Dunleavy, Detective Riley, who has identified himself as a member of the Manchester, New Hampshire Police Department. He has advised me the following of the right to remain silent. Anything I say can be used against me in the court of law. I have the right to a lawyer for advice before any questioning and to have one with me during questioning. If I can afford a lawyer, one will be appointed to me by the court. If I decide to answer questions now without my lawyer present, I still have the right to stop answering at any time. Do you understand? Yes.
Okay. Do you understand all of these, 1 through 5?
Yep.
Okay. What I'm going to have you do, just initial 1 through 5. That just indicates that you understand what I'm saying, right?
Yep.
All right. Can you just read that line
Do you
for me?
understand each of these rights? Yep.
And you're going to check either yes or no? All right. And then read the next line for me.
I will to have each of these rights. And are you willing to waive each of these rights and answer questions? Sure.
Okay. Now, Adam, you're just going to sign that line. All right. Appreciate it.
Before we go forward, can we get a cigarette?
So pausing here for the record at 2:32. Detective, I'd like to show you now what has been marked as State's Exhibit 2. We just watched in the video that you and the defendant go through a form together. Can you see State's Exhibit 2 on the screen in front of you?
I can.
I'll scroll through it. Do you recognize what this exhibit is?
I do.
What is it?
It's Miranda rights.
And specifically, is it the Miranda rights form that we just watched you go through with the defendant that night on January 4th?
Yes.
And based on this form, was it your understanding that the defendant had waived his Miranda rights and was willing to answer questions?
Yes.
I'd like to go back now to State's Exhibit 5 and play to approximately 9:53 in that exhibit. Can I confirm State's Exhibit 5 is loaded? So resuming from the 2:32 timestamp.
We go forward. Can we get a cigarette in here?
So, there's a sensor in there. So I'll work on getting you a cigarette at some point. I can't promise you one right now just because the room we're in, and if this starts going off, I don't want to.
Well,
It's like the building, you know what I mean?
It's like they're gonna go off.
That thing will, the sprinkler. So, but at some point, we'll work on getting you. I know we have cigarettes in here. I know where they are. Okay? You hear what I'm saying? All right. Do you need a water?
I don't need nothing.
You good? Okay. Are you okay?
No, I'm not okay.
Okay. What's not okay?
Nothing. What's up?
All right. So I'm just gonna ask you some basic questions. You said you can read and write English, correct?
Sure.
All right. Can you just state your full name for me?
Adam Montgomery.
And Adam, what's your birthday?
12290.
And what address are you using to
I'm
call?
not using any.
Okay. What phone number are you using?
I don't have one.
Okay. What was the highest level of education?
GED.
Okay. Where'd you graduate high school from?
I got a GED.
No, but I know, but like, where'd you get
While I
that?
was incarcerated.
Okay. Right now, are you under the influence of any drugs or alcohol?
No.
Okay. Do you have any traumatic brain injuries or anything like that? Anything that prohibits you from recalling any memories or anything like that?
Not that I know of.
Alright. Alright. So we've met before, right? We met the other day. I know you've had a long time down here. You've kind of been a roller coaster. I'm going to apologize for what happened out there. That's not how I do business, okay? That had nothing to do with me. Those are guys that like to play G.I. Joe, alright?
Pause, please. Yes. said, that your presence obviously is welcome in the courtroom, but we ask you not to be disruptive of proceedings when they're occurring. Thank you. You may proceed.
Thank you. So for the record, this was paused at the 4:24 mark. I'm just going to resume playing from here. Unless the court would like me to back it up for any reason.
No, you can proceed from there. Thank you.
If it had been up to me and I could have gotten a hold of you some way, I would have reached out to you. But you don't have a phone, right?
You guys could have just told my wife she wanted me to come in.
But aren't you not supposed to be talking to your wife?
No, that's bullshit.
It's not. You're not supposed to?
No, I can't be.
Thank you. Look at that. I can't be. I guess they're going to let you smoke a cigarette. They must have talked to somebody.
So I don't know why who's saying I can't talk to my wife, because that's bullshit.
Maybe it's some old paperwork that somebody saw?
Yeah, from last year, but it was over and done with after I got out of jail.
So that's all cleared up?
DCYF said it was cleared up, the police said it was cleared up, everybody said it was cleared. They said that there was no contact order between me and her.
Okay, and that's Kayla we're talking about? Okay. Well, you know, if that's the case, then that's my fault for maybe not checking a little bit further into it, so I apologize for that. Again, I apologize for the way things went down out there. Like I said, I'm not part of the SWAT team, I don't do that stuff. If I had had a good number for you, I would have just called you in. But I don't have you don't have a phone, you said, right? Okay. So I apologize for that. I do appreciate you being cooperative with me. You've never given me a hard time, and we've only met a few times, so thank you for that. Let's talk about why we're here to talk.
Tell me what you want to say.
Tell me what you know.
I don't know nothing.
Well, what was our conversation about the other day?
You said you had a couple questions you wanted to ask me, you asked me questions.
Well, what was our conversation about the other day? Remember we met, I mean, you remember that was only, what, a few days ago, right? We had a lot of worried people and scared people right now in the community. I know you're worried about the well-being of your daughter, and I kind of want to get ahead of this because I don't want you to be painted as a monster.
Well, that's what you guys are already doing.
I am?
Oh, yeah.
Can you explain that?
That's what you guys are already trying to do, man.
Explain to me how I'm trying to make you, or whoever is trying to make you out to be a monster. Who's telling you that stuff? Is there somebody that I work with that told you that? Somebody you're close with, that they told you that?
No.
Alright. But you understand this whole thing is getting a little out of hand, would you agree?
Of course. But,
so that's why...
Look, it's just the way you guys are going about it.
And again...
Yeah, not you specifically, but yeah, nobody comes out there like that for a second-degree assault charge. Nobody. Been arrested for worse charges, they don't come out and throw fucking flashbangs at my girlfriend's car and ram us into the fucking guardrail. They don't do that. For a second-degree assault charge.
Again, you understand what the charges are, right?
Second-degree assault, right?
Yep.
Okay.
There's also an endangering the welfare charge.
Okay.
And interference with custody. Okay,
So how did I interfere with custody?
So that paperwork that we served you the other day, remember that?
Okay.
When they were in the alleyway, remember outside of Lake Ave?
Yeah.
There's paperwork that you have to comply with. You understand that, right? We had that conversation, did we not? Right? So that's what that's all about.
So second-degree assault charge, what is this referring to?
Well, that's what we want to talk to you about.
Well, explain to me if I'm being charged with it, what the hell am I being charged with it for?
Well, your daughter had some injuries that you know about when you lived on Guilford Street.
No, I do not. What are you referring to?
Well, you were there, I wasn't, right?
What are you referring to?
I'm referring to her having some good marks.
What are you referring to?
Marks that were left on her by you.
Absolutely not. I have nothing else to say.
Like, we talked about how we were worried about your daughter the other day, right?
Okay.
You remember that conversation?
I remember that conversation, but right off the rip, with the way you're approaching the conversation, you guys are completely out of line, so.
Me?
Yeah.
Do I, in the time you've known me, which
But
is...
what you just said to me, you guys are completely out of line.
Okay, but so explain to me, how are we out of line?
I have nothing to explain.
Okay, but wouldn't you rather explain it so we can make sense of it than just have other people's side of the story? Like, you want to defend yourself and like this picture people are painting of you? Now's your chance, man. Defend.
Whose side of the story? Who's telling you these things?
People that were close to you.
Obviously not.
Well, maybe at the time, maybe not anymore.
So, for the record, pausing at the 9:53 timestamp. The interview with the defendant continued after this point, correct?
Correct.
And in all, it lasted about 35 minutes?
Yes.
In terms of the recording, the whole interview is split across 2 files, correct?
Yes.
And for the record, Your Honor, those would be State's Exhibit 5, which we were just viewing a portion of, but then also State's Exhibit 6, which follows immediately after. If I could have one moment. I have no further questions at this time.
All right, can you, counsel, approach for just a minute? Fifteen-minute recess.
All right.
Examination of this witness, and I'm going to turn to you, Attorney Smith. You may proceed.
Yes, Your Honor. I indicated that I would be playing the rest of the video, and the state has agreed to just, because they're all set up with the things, to just continue with their presenter rather than mine.
All right, one moment. Let me just pull this up.
And I'll note, I had stopped presenting when I ended direct, so everybody, I think, is going to need to follow me again.
To follow you again. Okay, very good. So I'm showing 9:53 on State's Exhibit 5. Right? And
That's where I left off.
Okay, very good. Attorney Smith, are you ready for him to just hit play?
Yes, Your Honor.
All right, you may proceed.
I mean, you saw that reward on the news, right?
No, I did not.
Do you know that the reward is about $40,000 to find where your daughter is right now?
Okay.
When you start throwing money around like that, people come out of the woodwork that you would never expect to do.
Okay.
So, like I said, when I talked to you a few days ago.
Can I have another cigarette?
Sure. I kind of told you this thing was going to get a lot bigger.
That's not right.
And we wanted to get ahead of it.
But you're sitting there telling me that, right off the rip, that there was something wrong with my daughter because of me. No, that's bullshit.
Okay. So if your daughter had marks on her at some point when you lived over there, how would you explain those?
How would you get those marks? Well, I would love to know when the marks were there because DCYF came to my house multiple times.
Okay. And we know that they came in.
Right. And closed the case.
Okay. Do we know that DCYF is the flagship agency in the country?
No, but if there was significant marks like you're referring to, I believe they would have flagged something at that point, and they would have said something. They wouldn't have came there and seen that the kids were well taken care of. All the kids loved being at the house with me.
So let me tell you about what second degree assault is. Because there's a lot that encompasses that charge. Basically, if there's a mark on a kid that's under a certain age, it constitutes second degree assault. Although it is a felony, which sounds extremely intimidating, it doesn't mean that somebody got their head bashed in or they got cut up or whatever. So, although it sounds pretty intimidating, the charge, I understand that. What we're talking about doesn't mean that it's the craziest crime that's ever been committed. Do you understand what I mean?
Okay.
So, somebody could have a bruise or a really bad welt on them, and that would constitute second degree assault for a kid under a specific age. So that's why that charge is there. So nobody is saying that you took like a baseball bat or like stabbed your kid. Like, I'm just going to put that out there. That is not what anybody's saying about you. So I know you're concerned with when I say second degree assault, but it sounds a lot worse than I think you're thinking it is. Are we kind of on the same page?
Yeah, but for you to sit there and say that it was inflicted because of me.
We're just going on what we hear. You're not telling us anything, so we're going with what we have.
But I don't even know what you're referring to. What are you referring to?
Your daughter had a mark on her face that multiple people, have told us was inflicted by you.
Multiple people that weren't even living with us at the time.
Well, there was enough people that had spoken about it.
Yeah.
People share knowledge of what they know.
So somebody, you telling him, and then he tells you, and then he tells you, so something that just gets passed down the line.
I'm not talking about like a game of telephone here. I'm saying that people say a story and then the details kind of fill themselves in, like corroborate. Do you know what the word corroborate means?
Of course I do.
Okay. You're a smart guy. I'm not trying to insult your intelligence, but when people kind of fill in the blanks, that's what I mean by like we're corroborating that story. But this is your time to tell me, kind of explain that. You know, if you're saying this was a mistake or this was an
I don't
accident.
even know what you're referring to. Like, that's what I'm trying to get at, is I don't even know what you're referring to.
I'm saying she had a mark on her face. I mean,
Okay, I don't even know what you're referring to.
you don't recall your daughter ever having a mark on her face.
The reason DCYF came out to visit you guys, you don't recall that? Why did DCYF come out and start visiting you guys? What was the allegation?
If I remember correctly, it was because of, I believe at the time, I could be wrong, I believe it had something to do with my uncle saying I was using drugs, and I wasn't.
Now, who's your uncle so we are clear?
Kevin.
Okay. And Kevin's last name?
Montgomery.
Now, he lived there with you?
He lived there with me right around the time when I was first going back to get custody from my daughter.
Okay.
And then he left in April, May, March, something around that time.
And just so I have it right, because I don't want to guess or like get confused, What house are we talking about?
Guilford Street.
All right, and what was the number there again?
I'm not 100%.
Okay. Do you remember what color the house was at least?
Beige, maybe.
Okay. And whose house was that originally?
My grandmother's.
All right. And grandma is who?
Kevin's mother.
Kevin's mother.
My dad's mother.
Okay. So was it the Montgomery group living over on Guilford Street?
Yeah, and they all moved out. My grandmother moved out in like January with my little brother, and they all moved down to Florida, and then Kevin went a couple months later.
And so grandma, uncle Kevin, you said little brother, and who's he?
My father's son, Michael.
So Michael, that's what I meant. Like, what's his first name?
Yeah, and his girlfriend.
And his girlfriend. And is he still with that same girl now?
I have no idea.
Oh, so you don't talk to Michael anymore?
No.
Okay. What was that girl's name at the time? Because maybe she can help us to say that, like, this is...
Kayla, I believe.
So Michael's girlfriend name was Kayla at the time? And you dated Kayla at the time?
Yeah.
So it kind of got confusing in the house if somebody was yelling for Kayla.
Yeah.
Okay. So, what was Kayla? Kayla you were with at the time was...
My wife.
Okay. Montgomery. And then Kayla he was with is...
I have no
idea who she was. Okay, so there was grandma and Kevin, they moved out in when?
Grandma moved out in like...
I'm just trying to think of people we can talk to.
I'm trying to figure it out. I'm trying to figure it out to go back. Like I think we moved over. Thank you. I think we moved over there. I think we moved over there in like, I don't know, October, September, somewhere around then.
And what year is that?
2018.
Okay.
And at the time, I was going for custody for my daughter for at least a year already at that point. And Crystal was showing no interest of going to get our daughter back. So finally, in like, I don't know, December, January, February, something along those lines, courts called me and told me I could come pick her up and bring her home. Brought her home. And then, I don't know, it was, I think the month before, my grandmother left with my brother and his girlfriend, and then the month after, I want to say, Kevin left.
So then who was left living at the house?
Me, Kayla, and the kids.
In that time period, I don't know which kids were born yet and who was.
It was Declan and Seamus.
Okay, and
then Hamdi moved in with us.
Okay. So what time did DCYF get involved with you guys? Like, were they over there often, or was it just like a certain period of time? Or
they were there every single day. The police showed up every single day, saying because that's what it was. That's what it was due. That's what it was due to. So Kevin moved out because between me and my wife and Kevin, we were supposed to like pay the bills, keep the heat on, the gas on, whatever. Well, Kevin was supposed to pay the electric bill. He didn't pay the electric bill. Me and my wife, I picked my wife from work, showed up at home. They were shutting the electricity off. So me and Kevin got into an argument about not paying the bill, and he took his shit and moved out. And then so the next day, or 2 days later, something like that, I don't know, DCYF showed up and the police showed up because they said that we were unfit to have the children at the house because there was no electricity in the house.
Okay.
But we had a generator running, we had the fridge hooked up to it, there was food in the fridge, everything was fine. The police showed up, seen that the kids was fine, there was nothing wrong with them. The DCYF showed up and they left.
And was that like summer, fall? Like when was that?
I want to say maybe spring, going into summer maybe.
Oh, okay, so like
you guys hadn't been there for too long then.
6 months or so.
Okay. And how did it end up that you guys got kicked out of there?
All right, so it was my grandmother's house.
Right.
They didn't pay the mortgage or whatever. They moved to Florida, so the mortgage payments weren't being paid. And I don't know, right around Thanksgiving sometimes, the sheriffs came and threw us out. And then me, Harmony, and Declan, Seamus, and Kayla left.
And where the heck did you guys go from there?
We were in our car.
Oh, so you lived in your car at that time?
For a couple of days.
Okay.
And then
did you have like a van or something like that back then, at least? What were you driving back then?
Chrysler of some kind, I forget.
Oh, so it was just like a sedan?
Car, sedan, yeah.
Okay, so you live in the car, so you, Kayla, and the 3 kids were living in the car for a few days, and then how'd you get up out of that situation? Like, who took you in, or where'd you guys end up?
We ended up going to our mom's house, Kayla's mom's house.
Okay, and what's her name?
Chris.
Chris, how's she, well, I mean, she must be okay if she's willing to take you guys in.
Yeah, alright, they're like, alright, I, you know what, man, like, I don't even want to talk anymore, like, this is just beating around the bush, man, it just seems a little too silly to me.
Well, I'm trying to figure out who can substantiate your claims that there's, like, you're not this, like, monster of a person that either DCYF made you out to be, or your family who you didn't get along with, or whoever. So that's why I'm trying to, like, let you kind of speak your piece about all that shit, you know what I mean?
No, I get what you're saying, I just got nothing else to say, man. And like, no, yeah, and like, I just don't want to sit there and like, can I smoke another butt?
Sure. I'll be honest, I don't smoke cigarettes. I'm a little lightheaded myself.
Alright, I just know I had smoke butts for a minute.
That's all good.
But yeah, no, but to sit there, man, and sit there and tell me you yourself too, like, this is why I feel like it's just all bullshit, this is just a game, I know it is, I'm not stupid, you fucking...
I'm just trying to give you the opportunity to explain yourself.
You're sitting here telling me not to make me out to look like some monster,
Well,
but
no,
I told my girlfriend the other day that she should get the fuck away from me, that you don't even know who I am, and what my past is like, and all types of crazy shit, like, but sit there and look me in my face, and act.
Adam, I think, you're talking about Kelsey?
Yeah.
Okay. I think Kelsey might be exaggerating a little bit.
I don't know her to exaggerate like that.
It wasn't us talking to Kelsey either.
Oh,
there was other people talking to her, just so you know.
She told me, she gave me your card and said this was the guy that said it.
Okay. Well, I'm telling you that I didn't say that. But if you want to believe it, that's fine.
I mean, she never had no reason to lie to me, so I don't know what she would lie about at that point.
She also told me she had no idea that you had a daughter, so I guess we could say the same thing about you telling her that.
Right, well,
right?
She knew I had a daughter. I mean, I have one with Kayla, so she knew I had a daughter.
She didn't know about Harmony.
She knew I had other kids.
She told me she had no idea that you ever like lived with her and that you like barely knew her. I don't know if she was lying to me because or whatever. I have no idea. I don't know her. I know you better than her, so that's what I'm saying. So Christina takes you guys in, and she's doing all right, and then would you guys move over to Union Street after that? Is that when you guys get that spot?
Nope, we go to the shelter.
And that's the one on...
Like, yeah.
Okay.
Who's we? Who went to the shelter? They allowed you to go as a family to the shelter?
See, I thought they didn't like guys there for some reason.
They always like guys there. They didn't let me in there this time for no reason. The reason was bullshit, because I would have been there with Kayla again.
So back then they let you in there.
Oh, yeah.
And it was all of you guys, like, it was the 5 of you, they let you guys stay there?
No. Alright, see, yeah, you guys are just...
I'm trying to understand, I don't know your timeline of life, man. You're there, I'm not. That's why I'm trying to ask you these questions, to clarify them.
I already told you the other day what transpired. So we didn't even go to her mother's house.
Okay, who didn't go to her mother's house?
Harmony was on.
Okay, so Harmony didn't go to Chris's house. So explain to me how she didn't end up going to Chris's house.
I've already explained this to you.
Okay.
Well, there's some discrepancies between what you're telling us and what other people are telling us. You're saying you brought her down to Mass, and somebody said she came up from Mass.
I never once said I brought it down to Mass.
What did you say? She came up here to get her?
I never once said. I was audio and video recording the other day. I never once said I went down to Mass.
So you're saying that she came up from Mass?
I'm not saying anything else.
Why is it that you refuse to talk about her every time we bring her up?
Because you guys are just sitting here beating a bush. It's over and over. You guys asked me what happened the other day. I told you what happened.
You wouldn't tell us the other day.
You guys talked to me the other day. I explained to him what happened the other day. And now it was just a charade. Yep, no, don't worry about it. You're not under arrest, and I'll come up with some fucking bullshit.
We didn't arrest you.
No, the other day, no, but then you had a fucking SWAT team roll up on me and the fucking D-Techs follow me around for the last 3 days.
Yeah, people are coming out of the woodwork. That's what we're trying to tell you. Like, we don't want you to be painted as a monster. We want you to maybe explain yourself a little bit and give us some side of your story. We have nothing. We have just what we're hearing from people. $40,000 and drag a lot of people out, whether you believe you're your friends or not.
No, I bet
it's a lot of money.
Yeah, I know it is.
So,
Absolutely it is.
That's what we're trying to get. Now's your time. Like, you keep locking up on us. You don't want to tell us anything about her.
I got nothing else to say.
I think you get.
So that's the end of State's Exhibit 5, the 27-minute mark. Counsel, would you like me to play State's Exhibit 6?
Please.
Can I confirm that loaded correctly for everyone?
Yes.
So playing from the 00 mark.
Care about your daughter?
Care about all my kids.
Right. But the one I care the most about is your daughter, Harmony. And we have people around the clock calling into us, giving us tips from all over the country because they care too to try to find where she is. My only goal, which I told you the other day, is to make sure that she's safe. I don't want you to get tied into something if you didn't do anything wrong. My job is not to jam somebody up for something that they didn't do wrong. And if you can tell me that you didn't do anything wrong, then I want to believe you because, dude, I've met you now a few times. I helped you out when you were at the hospital when you were having a fucking meltdown. You told me about your kids. I sat there and I talked to you. Dude, I could have fucking tased you right there, and I didn't do that because I saw deep down inside that you were hurting and that I wanted to help you. Right now, all I'm trying to do is help your daughter. I want to bring her home, and I can't do that without your help. Dude, I can't do that without your help. Help, hey, can you look at me? Help me, please. That's all I'm asking for. I can't sleep until I know that she's okay. And I know that you know where she is or what happened to her, but I can't do it without your help. And if you don't want to look like this fucking animal, because I don't think you are. Not that I don't think you are, I know you aren't. But I can only do so much for you, man.
I know.
I'm begging you to help me. Because as much as you're hurting inside, I'm also hurting inside, and I don't know how you can sleep at night because I'm sure it's eating the shit out of you. Am I wrong?
No, it's eating me apart. I know I'm not fucking seeing my wife, I'm not seeing my kids. You guys are just playing games like this. Is just
Dude, but I'm not trying.
We're not trying to play games.
Good. Like telling my wife and kids that I'm not allowed to see my wife and kids.
But dude, that was a mistake from some court paperwork that hadn't been updated. So like I said, I apologize for that.
But it was updated. DCYF told them.
No. This was some like DB paperwork I'm talking about.
But I'm talking about DCYF already told us multiple times that there was no contact order.
Maybe through DCYF. But
it could have been through DCYF.
Yeah.
So let's fucking forget about it. You've seen your kid, you've seen your wife and kids over the last, how many days, right?
I haven't seen them in the last, I haven't seen my kids in the last 2 days, 3 days.
Okay. You're always gonna be their father? Declan, Seamus, and then Sierra, right? Kiera. And then there's Harmony.
I got nothing else to say. That's it. That's it, guys. I got nothing else to say.
Can you make me a promise? Like, man to man? Can you tell me that she's alive?
You're gonna play the same word games that you played with me the other day.
It's not word games.
I got nothing
Because
else
we
to say.
care, man, we wanna know.
This isn't gonna go anywhere. Like, this isn't gonna stop. So
I know it's not.
So either get on the bus now or get run over.
I got nothing else to say.
Why is it you have so much trouble talking about Harmony?
Guys, I got nothing else to say. I want a lawyer with me.
Well, we just copy this ex parte or it's a petition from DCYF.
Can you pause that for a second?
You can read it later sometime. I'll put it in your property. It's basically the same thing you got the other day. It's just a little more detailed that we handed you. It does say that your order.
Okay, you can restart it. For some reason, it paused, and I'm keeping track of the numbers on the bottom, so that's why. But it's now caught up. Are you at 416?
416.
Yes, okay, you can proceed.
Should I rewind it at all or proceed?
No, I could hear it. If I wanted to write down where it was, I couldn't because it had paused for a moment, but go ahead.
Okay, I actually have a question there. Where are you seeing the numbers on the bottom? Because every time it plays, I don't see the numbers.
If you kind of just scroll over the video itself, you can bring those numbers up.
Okay.
Shall I resume?
Back up, I think? Did you?
No, I heard everything.
Okay.
They're sitting at the table, but unless there's something that you needed me to see in that half a minute, I'm fine. Go ahead.
Okay, so for the record, that was paused at 416, resuming from 416.
Thank you.
It does say that you're ordered to help us locate Harmony, but you're telling us you're not gonna do that.
I'm just telling you guys I want a lawyer.
It is 9:25.
Oh, no, there's no more people to talk to. The video goes on with nothing, Your Honor.
Okay, I have it ending at 4:53, even though it's a total of 8:26. Yes?
Okay, so now I hit as presenter. Where's okay, before I, didn't I?
Hang on one moment.
No, I think they just haven't caught up.
I'm not seeing you as an available presenter, so I'm going to have to click start.
You just click stop.
Oh, there she is.
But that's not what I have, okay. Okay.
Great, I'm going to follow you now. Yes?
I'm gonna have one question that I'm just setting up for next.
Okay.
Okay. So, the video speaks for itself what happened in that room, but I want to ask you, after that interview, did you follow up on whether DCYF had allowed contact?
I didn't personally, no.
Okay. Did you pass it on that DCYF had appeared to have allowed contact?
Somebody might have at that point, but I can't speak for that.
Okay. Okay. All right, I have a few more questions, but I'm going to play this next one. Now, I think on direct, the state played a portion of Defense Exhibit B. Is that correct? That's what you were playing from? Okay, Your Honor, I am starting this video from the beginning.
Step out. Hey, here's where I can see him.
What's going on?
What's your name, my man?
What?
So pausing it for a second, do you recognize this to be the area where Mr. Montgomery was questioned by you in the morning of December 31, or do you need more to?
No, I recognize that area, yes.
Okay. And I will continue.
Adam? You have anything on you?
No.
All right, come right over here.
What's wrong?
I'm just gonna pat you down, make sure you don't have any weapons. Put your hands on top of your head, okay? On top of your head.
What's going on now? What's the problem right now?
All right. Who's this in the car with you?
My girlfriend.
How long have you been back in New Hampshire?
I don't know, for like a day.
Not sure what I think I must.
I can't with these people. I am literally dying.
Press space key to play.
Look at her struggling. I can't.
Attorney Smith, do you want a little technical assistance?
Yes, please.
Thank you.
Roberta,
Okay. Everybody may need to refollow. Start all over.
Roberta,
I don't want to talk to him. Can I just get a cigarette, please? Can I just get a cigarette, please?
What are they doing now?
What you guys got down here? I don't understand, like, what the fuck all this, what was all this about, though? 5 cruises for what?
What's that?
5 cruises for
Guys
what?
are just driving around looking, so
Driving around looking for what?
usually nonsense stops around here. That's it. So,
Can I get my jacket on?
we'll grab it.
Yeah, where is it?
Who's that? Yeah, I think I'm doing something wrong, right?
No, dude.
You got any weapons in here?
No, there's nothing in there. All right.
So you know you're recording as well, right?
Yeah.
Been working?
While I was up there, no.
How long were you there?
For months.
A couple months.
Is this your car, Adam? Your car? Where you guys been staying at?
I just came back down here.
You just came back?
Yeah. What's she under arrest?
It's just being nice to her because she doesn't have any socks on, man.
People stand around cold. Wet feet.
not here to give anybody a hard time. I'm just trying to figure some stuff out.
I will coming to talk to you. I can't. You guys talk. I don't want to talk to them.
You can have that conversation with them.
I don't want to have that conversation with them. I don't want to.
Okay, so at that point, Adam Montgomery said that he was told that detectives were coming to talk to him and he didn't want to talk to him. Is that right?
That's what I heard on the video.
Okay. And you recognize, do you know whose body cam this was?
I believe it's Officer Stanzel's.
And Officer Stanzel was also at, what was it, Lake and Union later on that afternoon when Adam was stopped?
I don't believe so, no. He would be a midnight officer, if I remember correctly.
Okay, okay.
People are concerned about stuff, but we want to make
Because
sure
I'm not talking to the police about nothing. I'm not under arrest.
right now you're being detained, yes. Not under arrest, but you're being.
Okay, so at that point, Adam said he wasn't talking to the police about nothing, right?
That's what I heard, yes.
And asked if he was under arrest, and he was told he was being detained, right?
Correct.
Any particular reason you don't want to talk to him?
I don't talk to fucking police.
What's that?
I don't. Should I call a lawyer?
Where's your phone at, my man?
Don't worry about it.
I'd rather just see you be on your way.
Who would?
All of us.
Yeah, we don't want to be standing out here in the cold either, man.
Well, it's a little crazy, you know? For no reason.
But let's be real. Some of us have been around for a long time.
Nah, it's
All right.
not
So.
Right.
492-7507. 7507. Will Prius to United Transportation.
How old are you, man?
31.
31. You grew up in Manchester?
Moved out there when I was like 15.
From where?
Mass.
Nah. You finished high school here?
Nope.
No. Where from Mass?
Yeah.
Alright, you're a Boston kid. You understand, we're not trying to jam you up here, right?
Okay.
Like, we want to, if there's anything we can do to help you, if there's anything you need to tell us, you know.
Nothing at all.
All right. How long you been with her?
Couple months.
Couple months. How long have you guys been living out of this?
Just moved. Just came back down here. Trying to find a place to stay out here.
Gotcha.
Like my sergeant told you, my body camera's running, all right? I'm audio and visual recording.
No. Number one. Who's on the desk? Alright, Val.
What?
No, what needs to come back down here? More opportunity?
Yeah, there's shit out there.
Like whereabouts is it?
Like 15 minutes from Bangor.
No. So like halfway up here. Yeah. Not like up on Caribou.
No. That's where her feelings from.
Caribou? What part you got? They don't live in that little town that you guys were in? Or?
What they do?
Oh, they do now?
Nothing.
It's like a whole long fucking transplant for nothing, right?
Yeah.
I'm going to lose my mind.
Yeah.
No tree work or anything like that up there?
There's nothing up there at all. Doggy's out. All Christmas.
You mean her down here?
Midnight. Like, no, not midnight, but like 4 or 5 a.m. Staying in the car right now. Yep. Anything.
What do you typically do?
Copy. Yeah.
I was going up with fucking crazy.
I know.
No housing where everybody's building fucking everywhere, you know?
Yeah.
So, my sergeant knows you, apparently you used to rip and run and you know, you've been nothing but cooperative with me, all right? And I appreciate that. You guys want to talk to, you know, it might behoove you to answer some of their questions, you know? Hang right here for now. You used to get after it a little bit?
Yeah.
Slow down or? You use still?
I haven't for a while.
I mean, you don't look like you're torn up.
I haven't for a while.
what's going on?
What? All right. Am I under arrest?
No, you're not. You're not. You don't have any warrants.
All right, I got nothing to say.
Adam, right? Montgomery?
Yeah. Yeah.
I don't. Do you remember me from the Elliott Hospital from a while back, man?
Yeah, I got nothing to say.
Okay, and you saw and heard on that video that Adam had said that he didn't want to talk to the detectives, right?
I did.
Didn't want to talk to the police, right?
Correct.
Didn't want to answer any questions, right?
Correct.
And you heard the officers there, especially at the end there, suggesting that he cooperate, right?
I heard it on the video, yeah.
Okay. And you also heard some questions about like whether he was using or not, right?
Mm-hmm.
And then you said on direct, I believe, that when you arrived and started to talk to him, that he said that he didn't want to talk to you, right?
Correct.
And that he repeated it several times, right?
Correct.
And that you did continue asking him questions, right?
I did.
Because you wanted information from him, right?
About the location of his daughter, yes.
Okay, and you wanted information from him even though he said he didn't want to ask questions, right? Answer questions.
Yeah, he said he didn't want to talk to me.
Okay. And you continued to question him notwithstanding that, right?
Correct.
Okay. Your Honor, I believe that I can play the remainder of the videos that I want to play without necessarily this witness. I think the state agrees that they are admissible without the witness there.
That's correct.
All right. Okay, I'm sorry, one more thing that I wanted to ask. I believe that you testified on direct that you discovered or saw Adam speaking to Kayla after you seized the phone, right?
Correct.
Okay. And that was maybe 10 minutes later or so?
Probably less than that, but you're about roughly, yeah.
Okay, he left the scene and you talked to some people there and then you were walking around to talk to Kayla, I think. By the way, Families in Transition is where Kayla was staying, right?
So I walked around, I'll answer your first question. So, yes, I walked around for a minute or so, and then Detective Riley notified me that Adam and Kayla were communicating out front of Families in Transition, 177 Lake Ave, and that's when we made our way towards them.
Okay. So you were at the scene, Adam had left, and then you got a report that he was having communication with Kayla at Families in Transition, right?
It wasn't a report, we witnessed it.
I mean, I think that you said Detective Riley reported to you?
Yes, yeah.
Okay. Not a written report,
Right.
a report
Just
from
wanted
Detective Riley.
clarification.
Gotcha. Very disconcerting with this high podium, sorry. And so you walked over there and you made the observation yourself, right?
Correct.
But this was after the events at Union and Lake with Adam, right?
That's right.
And this was after you had seized the phone and Adam had left, right?
Correct.
Okay. And the fella in the video that we saw before who talked to, police officer, but I think he was in plain clothes, the one who asked Adam to give him the phone.
I think you're referring to Detective Papalardo.
Is it? Okay. All right, for the others, Your Honor, I don't think I need this witness to play the additional videos that I'd like you to see, so I don't have any more questions of him.
All right. Do you have any, are you going to have any further questions? Do you anticipate, do you want him to stay?
No.
Okay. You may step down.
Thank you.
Okay, let me try and...
Shall we call the next witness?
Oh, sorry.
Well-
I was thinking,
Oh.
no, it was my mistake, but you're right, the next witness, and then I go, yep,
Okay, so I was in, so you're not playing the additional videos now?
correct.
Yes,
When
right,
it's my
that's right. Yes, go ahead.
Okay, the state calls Scott Riley. Could you raise your right hand? Do you swear the testimony that you're about to give will be the truth under the pains and penalties of perjury?
I do.
Good afternoon.
Good afternoon.
Could you please state your name and spell your first and last name for the record?
Detective Scott Riley, S-C-O-T-T. Last name is R-I-L-E-Y.
How are you employed?
I'm a detective with the Manchester Police Department.
How long have you been employed with the Manchester Police Department?
I've been with Manchester, I'm in my 16th year.
And what is your current assignment within the Manchester Police Department?
I'm a detective in the juvenile division, investigate child abuse and sexual exploitation cases.
Drawing your attention to December 31st of 2021, were you working that day?
I was.
And specifically referring to the afternoon of December 31st of 21, what was your responsibility?
Specifically in the afternoon?
Yes.
To serve an ex parte to Adam Montgomery.
Was anybody accompanying you in that task?
Detective Dunleavy.
Had you received a copy of the ex parte order yourself?
I did.
So if I could show you through the monitor there, I'm going to show you State's Exhibit 3. One moment, I need to start my presentation. I have started my presentation. So for the record, this is an exhibit that has been placed under seal, but Detective, can you see State's Exhibit 3 on the monitor in front of you?
I can.
I've paused my presentation, so you should be able to scroll through it using the touch screen. Can you do that?
Yep.
Can you just look at State's Exhibit 3 and confirm whether or not that's the ex parte order you were tasked with serving on Adam Montgomery that afternoon?
Looking for my signature at the bottom. I believe it is. It is. That's the one.
So yes, State's Exhibit 3 is the ex parte order you were serving on Adam Montgomery that afternoon?
Correct.
And did you in fact encounter Adam Montgomery to serve him with the order?
I did.
Where did you encounter him at?
Lake and Union, alley in between Lake and Spruce.
In Manchester?
Yes.
And about what time did you encounter him?
Around 4 p.m.
Were you the first officer there with Mr. Montgomery?
I was not.
So when you got there were already other officers?
Yes.
But when you got there, did you interact with Adam Montgomery?
I did.
Do you see him in the courtroom today?
I do. He's wearing the orange at the defense table.
Could the record reflect identification of the defendant?
It shall so reflect.
Detective, were you wearing a body-worn camera that day?
I was not.
Why not?
Not required. We were in like a dress outfit. We're not wearing uniform. It's our choice whether we do or not.
Can you just explain that a little bit more? Why was it that you were not required to wear a body-worn camera that day?
The uniform, like if I wear a police jacket that says Manchester Police on it, it's just part of our SOPs. We're required to wear it at that time.
And on that afternoon of December 31st, can you describe generally the clothing you were wearing?
Similar to what I'm wearing now, minus the coat and the tie. Just a dress shirt. We're allowed long sleeves, short sleeves, whichever we prefer, but dress pants and dress shoes.
You weren't in a full police uniform, were
No.
you? You're aware that other officers did have body-worn cameras on during that interaction, correct?
Yes.
And that video of, at least video of your interaction with the defendant was captured?
Yep.
So I'd like to show for the court again just a clip of Detective Riley's interaction with the defendant. This will be from Officer Beery's body-worn camera, which is State's Exhibit 1. I'm starting my presentation.
Showing on yours. Is it showing on yours now?
Oh, it is, yes.
Oh, okay, hang on, it's not showing on mine personally.
I think for some reason my presentation was stopped, so people I think we'll have to re-follow.
It's up.
Defense?
Yes.
Okay. So everybody, I'm going to be playing starting at 9:20 in State's Exhibit 1. Is that what everybody sees?
Yes.
Yes.
I've never been cross paths. Big deal. Forget back. Phone.
So I'm pausing at 9:30. Detective Riley, do you see 3 figures towards the camera in that video?
I do.
Going from right to left. Who's the one on the rightmost side of the screen?
Detective Dunleavy.
And then somewhat to the left of him, next to the letters LICE in the police car, who's that?
It's me.
And then the figure with his back to the camera looks like a dark hoodie and maybe a baseball cap. Who's that?
Mr. Montgomery.
Continuing to play from 9:30.
Yeah. Would I be working there? Abby, you working? Yeah. What's up? Yeah. Here comes Scotty Trudeau.
And then ending for the record at 10:30 in State's Exhibit 1. So Detective, we just watched beginning at 9:20 to ending at 10:30 on the video. Was that clip we just watched the entirety of your interaction with the defendant at that time?
It was.
So approximately 1 minute or so?
Yes.
Can you describe how that interaction with the defendant began?
I walked up and just kind of separated him from the group of people, the officers that were standing there, and for his own privacy, I walked, I don't know, probably 30 feet down the alley, 25 feet. I explained to him that I had an ex parte order, and he immediately asked me if he was under arrest. I told him he was not. I just explained to him that the order compels him to help the Manchester Police Department with locating his daughter Harmony. He asked me again, am I under arrest? Can I leave? I'm not answering any questions. I stated to him, you know, you being her father, you owe it to her to tell us where she is and follow this order. And he said, I'm not answering any questions, and he was free to go.
So what you just described, was that essentially your memory of what you remember from that approximately 1 minute interaction?
Yes, I pointed out the portion of the ex parte. I didn't read the whole ex parte to him because it's a lot of information that's, we're trying to locate his daughter. So I showed him the point where the judge ordered him to tell us, or to work with the Manchester Police Department. That was the only portion that I actually pointed out to him, and then I left him with a copy.
And I think you mentioned at some point during this interaction, you told him that same thing, that the court was requiring him to cooperate with the location of Harmony?
Yes, because DCYF had obtained custody of Harmony.
And what was the defendant's response when you told him that he had to cooperate with the police department regarding the location of Harmony?
He said, am I under arrest? Am I free to leave? I'm not answering any questions.
Did you have any further, other than what you've just testified to Did you have any further conversation with the defendant at that time?
I did not.
If I could have a moment, Sean.
Yes.
So I want to again ask about that. When you pointed out to him that the order required him to cooperate regarding the location of Harmony, do you remember exactly word for word what his response was?
I don't remember exactly what he said. Something to the, if I'm not under arrest, I'm not answering any questions. I don't remember exactly.
Did you write a report about this interaction closer in time to the interaction?
I did.
And do you recall in that report, did you document more precisely what his words were at that time?
I absolutely would have. Yeah.
Would seeing your report on that interaction refresh your recollection as to specific wording?
Yes.
May I approach?
Yes, you may.
So, Detective, I'm going to show you your report from that interaction. I draw your attention to the second paragraph, but feel free to review whatever you need to. And then look up when your recollection is refreshed.
Okay. Okay.
Is your recollection refreshed as to the specific words the defendant said in response?
Yeah, he said I'm not answering any questions.
And just prior to that, did he say anything specific in response?
He said either arrest me, let me go, I'm not answering any questions.
No further questions at this time.
Hi, Detective.
Hi.
I'm Caroline Smith.
Nice to meet you.
So, I couldn't figure it out. Do you recall when the ex parte was provided to you?
It was that day. I don't know the exact time. It was, I believe it was emailed to me.
Okay. In your report, you don't indicate. Do you know if it was well prior to being advised that Adam had been stopped at Union and Lake?
It was, yeah, it wasn't minutes. It was probably, I think there's a second report with an interaction where I spoke to DCYF throughout the day. We were trying to update them as the case went on, so it was, we were kind of talking all day. I don't recall exact, I would say at least an hour, but I'd have to look back at my emails and see the time on my email when that actually came through.
Okay.
I don't recall.
And this report was on your interaction with Adam was written on January 1, so that would be the next day, right?
That's probably correct, yeah.
Pretty close in time, right?
Yep.
Okay. And so when you stopped Adam, and I know you've already testified, but I want to get it in the order. You show him the ex parte, right?
Correct.
So he was actually, when you approached, he was with a group of police officers, and he was allowed to sort of go around the corner to talk to you,
Yes.
right?
I asked him to walk over to talk to me.
Okay, you sort of did an indication and...
Well, I have something to serve you, and he walked over to talk to me.
Okay. And so the whole time that he was talking to you, obviously you were present, right with him, right? And you told him that you had a ex parte order, right?
Correct.
And you told him that DCYF had obtained custody of Harmony,
Correct.
right?
Yes.
And you told him that if she was located, she had to be turned over to DCYF.
Correct.
And you told him that he must cooperate with the Manchester Police Department and tell you where Harmony was at that time, right?
According to the order, yes.
And he stated that either arrest me or I'm leaving. I'm not answering any questions.
Correct.
And you have that in quotes. Are those the exact words or pretty much the meaning?
Yeah, that's what I put in my report, so I believe that is his exact words.
Okay. And you asked Adam to give you a location for Harmony, because he's her father and owes that to her.
Correct.
And you asked that after he said he wasn't answering any questions, right?
Correct.
And he stated again that he wasn't answering any questions, right?
Correct.
And do you recall after that exchange that he had with you, he was moving towards where those officers had him before?
Yeah, he walked back that way, yes.
And Detective Dunleavy was the one that approached him after that, right?
I believe so. I didn't hear the conversation. I don't think I was that close, or I wasn't paying that much attention, but yes, he did. I know he did go over towards him.
Okay, and then you watched Detective Dunleavy talk to him, right?
I knew they were having a conversation, yes.
Okay. And you did not pass on to Detective Dunleavy that he said he wasn't answering any questions, right?
I did. I told him he did not give me any information. I don't know if I indicated by like a shrug of the shoulder. He knew what I was going to ask Adam. So I don't know if I told him directly. He didn't tell us where she is, or I just said, gave him like a no. I don't know how I interacted with him. He knew that he wasn't providing any information when I walked away.
Okay.
I don't recall if I gave him like a head nod or if it was an actual verbal, he's not telling us. I believe I told him he's not telling us.
Okay. And you were with Detective Dunleavy in the interrogation of Adam Montgomery, is that right?
I was.
Okay. Thank you.
Any further questions from the state?
Nothing further.
All right, this witness may step down.
Thank you.
Any additional information the state wishes to present?
So the one thing I would say to the court is all of the state's full exhibits have been at least discussed by the various witnesses. I would note that specifically State's Exhibit 7 was played almost in full, but there was maybe a minute at the end that was not played in open court. State's Exhibit 8, only a portion of that was played. And then State's Exhibit 9, only a portion of that was played. I understand that the court will review the exhibits in full. I don't intend to play all of those videos, especially State's Exhibit 8 is largely duplicative with State's Exhibit 1, just a different camera angle. So I'm understanding that the court will review those videos as part of the court's review of the case. Those are submitted as full exhibits, but I don't intend to play those now. So in terms of additional evidence to provide at this point, the state has nothing further.
All right, let me just ask you, Attorney O'Neill, for example, one of the exhibits was played, there was more left to it, but nobody was sitting at the table and nobody was saying anything. So some of these videos are longer. There's substantive information in 7, 8, and 9 that was not played for the court that is for the court to view.
So in 7, there's not. It's basically just the officer is from what I can understand, repositioning his vehicle and not really interacting with anybody at that point in the video. In 8, like I said, everything on. I played a different angle of the interaction where the phone was taken from Mr. Montgomery. I played that from both State's Exhibit 1 and then a small clip from 8. The rest of 8 is basically just another angle of that entire interaction. So nothing additional that is substantive. State's Exhibit 9, there's additional information there, additional conversation, but what I played was the entirety of the interaction with the defendant from State's Exhibit 9. And to be frank, the additional time on State's Exhibit 9, so the full State's Exhibit 9 is 11 minutes. I played just the first 1 minute for the court. The additional 10 minutes was basically added on there at defense's request, so I believe defense will be potentially referring to that additional 10 minutes.
Okay, thank you. All right, so I will view those. Is there anything else the state wants to add?
Nothing.
Okay.
And I certainly have no objection to that request, and that was my understanding as well, that although only a portion might be played, the entire exhibit is in as a full exhibit.
Okay, and other than the issue that we discussed related to the expert that we discussed earlier, does defense wish to present any evidence, or do you just need a ruling from me on whether or not I'm going to allow you to present that?
I have some additional videos as well that I was going to present.
Okay.
And then Mr. Gurecki.
Okay, so, and about how long, do you have any just sense of just deciding whether this is a good time to break, or whether I should allow you to play the videos first?
Probably this is a good time to break for lunch.
Okay. Do you have some sense of how long the videos that you're going to play are, just so that I...
Again, because I'm going through them and like the state trying to get you to the very relevant portion, I expect less than 20.
Okay, I'm just trying to get a read. All right, so why don't we do this? Let's break so that you all can have lunch. We'll break for an hour. We'll come back at 1:30 for the presentation of the defendant's evidence, and then we'll hear arguments after that. This was scheduled for pending motions. If you wish to have oral argument on the motion to sever, I'll hear brief arguments from the parties at the time that you're arguing the suppression as well. If you feel that it's unnecessary and the court can rule on the papers, I'm happy to do that also. All right? Very good. Thank you.
But the cover revenue station is right down the road. No, you know where it is, right?
Yeah.
So you should be here in a minute.
All right. Let's go.
You guys can bring it for a second?
Yeah.
All right, thank you guys.
You taking off?
I'm gonna leave, yeah, so I think it's Detective Dunleavy who's coming to speak with you.
All right.
I am, okay? Thank you, brother.
John?
Jack, yeah, John, I think it was with John, yeah. Great.
And the purpose of that, Your Honor, the exchange with regard, the detectives are coming to speak with you, and there at the end, Detective Dunleavy, the officer you spoke to this morning, is coming to speak to you. Next, I am having exhibit four. And this is Officer Sardo and
Okay, just for the record, Attorney Smith, I think...
think what?
So the exhibit is Defendant's Exhibit D, correct? So what you see as 4 on the left-hand side, that's, I think, a case lines number, but that's not the exhibit number. So when you're referencing them, please reference the exhibit number that's marked at the top left corner.
Thank you.
I'm sorry.
Yes.
My computer just has disconnected itself from the internet, so I'm gonna have to reconnect the case lines.
Okay.
Okay, I'm good, thank you.
So I'm starting from the beginning.
I didn't know what No, it's I'll tell you the story. I didn't know if it was a sound stop. I don't know if it was a sound stop or what.
The purpose of that, Your Honor, as I put in the motion, that there were police officers who were armed, and at the stop, there was one with an assault rifle. That was the assault rifle being put away. And I will move on to 6:30. Close enough, I'll just go past it.
You're on channel 5. What's this red light? Is it dying or? Oh, okay. That's not my phone. It's not? Oh, it's not yours, you're just using it? Who's in there? Your friend? Who's your friend? Okay, I'll let him talk to you about that. I mean, this is his thing, whatever. Let's talk to you about the phone.
And I'll stop there. That was that's not my phone, not yours, you're just using it. Yeah, whose is it? A friend? I believe I have another word that is even clearer later.
But he'll give you all the fucking. You know what I mean? Was it Bart?
Cool. What you need, pal?
All the scene where right, he took the phone and said he.
Yeah, he's coming right back with it, bro.
And that was for the expression of where is he took the phone. And I think that is all on this video. Again, I know you'll be watching the whole thing, and a whole lot of it is repetition. The next one that I have is Martin's, which is State Exhibit 8, is that right? Yeah. And he's starting at 2:55. And this, I believe, goes through each of the things that I just showed you and some more.
Question like that. I spoke to them this morning. You could ask them right from the horse's mouth when they get here. I think that same detective that talked to you this morning is going to be the one that comes here. To speak with you. These dudes are going to stick up in the hand for a second until they get it. But
You work today, don't after this? No, I'm working. No, today's a day one. Yeah. I don't know how you like it. Just chat.
I'm going to leave, yeah, so I think it's Detective Dunley who's coming to speak with you.
They told us how to roll.
Thank you.
And you just like take them right now.
Yeah, John.
Yeah. So I really walked into the call. He goes, go. Like, and so I hear you guys in the radio. I'm like, fuck, we're late. So I'm like trying to we all were late. Or so I'm like trying to catch up to you guys, and then like yeah, back off. And just,
Oh, that was you guys? Oh, they were yelling at me.
sorry, I got you yelled at.
Sorry. Not a little overboard. Guys, like I'm just. No.
What's that?
I was saying, it's not overboard. Like all the police for like one person. I was
It looks like a lot. A lot of these cars are 2 main cars. So each car.
Enough. I'm gonna grab my hat.
You should.
We shouldn't need it. Yeah, he did. You did it? Hey, get your phone.
Do you have a cell phone on you? Yeah. All right, I'm just gonna have him hold it for a second, just till the detective gets here. This might be being. Did you call? So this is all about your daughter, right? This is about the thing you talked about your daughter.
You're on channel 5. What's this red light? Is it dying or?
Yeah, it's dying.
Oh, okay.
And that's not my phone.
It's not?
Oh, it's not yours. You're just using it. Who's it?
It's my friend.
Your friend? Who's your friend? Okay, I'll let him talk to you about that. I mean, this is his thing or whatever. I'll let him talk to you about the phone. Just give it to me. He'll give you all the fucking.
You're making him angry.
Grim?
Yeah, look at this. He wasn't barking till you walked in. You get cats or something?
Probably.
You don't know if you have cats?
Cash?
Cats.
Oh, cats.
Felines.
No, I don't.
a joke.
Contact.
It was a joke.
What, for a waiver?
Lighten up. Come on.
I'm married. Where do you go?
Oh, to see where right he took the phone and said, yeah, he's coming right back.
And again, that was up to where he was seeing where when he took the phone. I believe that is, sorry, Paul from, if I have another number down, and I think that's wrong. That was all from this one. Next is Defendant's Exhibit E from Officer Cowett. And I am going directly to, again, it's the same areas and interaction. I'm going to.
Honey, we're not doing
And you will recognize from other testimony that was Detective Riley speaking with Adam Montgomery, and then Adam Montgomery turning away when that was done.
So that's paperwork that's saying you gotta not see it again.
And that has the verbal of the beginning with Detective Dunleavy. He is not on that camera shot, so I will go to the next one, which is Bates. Officer Bates, Exhibit F. And this one goes to 4:45. Not the
recording muted. No longer muted. No longer muted. No longer muted.
And stopping because I think at the white part of the police car, you just saw images of Detective Riley speaking with Adam Montgomery, and that is the focus coming up to when Detective Dunleavy approaches him.
That's saying you gotta not see it
So that's the audio presentation that I had. Again, all of the videos are in, but that was to point out specific areas not covered or not as well covered by others presented. So the only other witness I would have is Richard Gorecki.
All right, so let me address the admissibility of that now. So I've, at the break, had an opportunity to consider the arguments that were made and to look at State versus Page. And my view is that that is not admissible on a four corners or facial challenge, as has been asserted. And so for that reason, the court is not going to allow the witness to testify. The court also notes that standing remains an issue, and the evidence of any testimony regarding the four corners, even if it were admissible, might be obviated by the standing issue, depending on what the court decides. But at this time, given that it is not a challenge with respect to a misstatement, misrepresentation, or materiality, the court is going to grant the state's request, not exactly on the basis that the state has moved in the sense that they assumed that you were arguing that misstatement or misrepresentation, but on the basis that that is not the basis of that motion to suppress, as we discussed earlier. So that witness will be excluded and not permitted to testify at this time. Is there anything?
On that, Your Honor,
yes.
as I indicated, that given the state's response, I will be supplementing the motion at some time in the future with regard to misrepresentation.
Are you within your time limits? I mean, I know that, the defense has, we scheduled this short turnaround time based upon your request. I don't think it's a supplement. I think it's a new motion. Would you agree with that?
No problem with that. Right.
Okay. Well, I guess at that point, we would address timeliness. Would it be considered timely? I don't think so, right?
Of your original request for our filings, yes. That was August 3rd, I think, or 1st, and we extended twice. So I'm not within your order for our motion to suppress, no.
Okay, I'm just trying to better understand how we're going to have a new motion to suppress filed that you suggest is timely, have a hearing on that, and have trial when you've asked for trial to be held. I don't remember, and maybe the state, what was the motion to suppress deadline?
It was August 1st.
Oh, okay.
And then got extended, but.
Okay, wait a minute. When you say then it got extended to?
In August, I think 19 or something, yes. So I'm saying we are past your deadline, yes.
Okay.
But it may not be relevant to the gun charges that are coming up in November. I'll have to relook at that, and if so, I'll probably have to file something for a continuance, but I don't know that there's relevant information on that.
I guess we'll address it should something be filed. Okay, so I'll hear argument when you're ready, Attorney O'Neill.
So may I just, on the issue of Mr. Gorecki's testimony?
Yes.
So one exhibit that had been uploaded by the defense and that the state had initially agreed to as a full exhibit was his expert report. It's Defense Exhibit A.
Okay.
So at this point, I would ask that the full exhibit be stricken. I understand maybe for identification purposes, but even then, I'd ask the whole thing be stricken since his testimony is being precluded.
Okay. Trey Smith?
I think it has to stay in for identification purposes if there's an appeal on your ruling.
So it's going to stay in, it's not going to be removed to the extent it hasn't yet been marked as a full exhibit. It will remain as identification and the court will not consider it.
I will say we agreed to a full exhibit, so I will.
Oh, it has been admitted? Okay. So I guess it was already marked as a full exhibit as agreed to, but given that there's going to be no testimony on it, the court won't consider it.
Thank you.
All right, I will hear argument.
Does the court have any preference on the order? So if I'm counting correctly, there's 4 pending motions.
Right.
One for the statements from the afternoon of the 31st, one the 4th, one on the phone, and then the motion to sever as well. Does the court have preference on the order in which you'd like to hear those?
So let's do the 31st. Let's do it essentially chronologically, and then the search warrant, and then the motion to sever.
Okay.
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 Go ahead, Gary, I'm sorry.
You go first, here.
It's your motion.
But it's your burden.
That's true.
Your Honor, I think we're not talking about obviously the morning of the 31st, that's already been really
Yes.
addressed by pleading, so I'm going to jump directly to the motion with regards to the afternoon statements from the 31st. Your Honor, as you go through and you've heard, well, not only have you seen those statements, you've been able to listen to those statements, but as you can see also, what you don't have here is the state, as we've stated in our pleading, we're not saying that the defendant was not in custody at the moment, that he wasn't detained. Clearly, he was detained, so the state is conceding that. But the question then, when it comes to a suppression of statements, is A, what are the statements? And then B, are those statements made in response to questioning or as a result of the functional equivalent of interrogation? And we do not have that here. I'm not going to, because I take it, Your Honor, you've already read the pleading, so I'm not here to just restate everything that's there. I'd like to just kind of focus in on the fine points of that. The statements that we have that are being asked to be suppressed at this time are, first of all, the statement made to Detective Riley, "Are you arresting me?" And clearly the answer to that was no. That was a question that was being asked by the defendant, and no, he was not being arrested. He was there to be served with an order and have items from that order read to him. The second statement that's being asked to be suppressed is his response to Detective Riley when he's following the court's order about telling him what's there, his statement at the end saying, "Either arrest me or I am leaving. I'm not answering any questions." Now, there's two parts to that, of course. As the state's put forward in its argument, we're not seeking to have the second part of that, the second sentence, "I'm not answering any questions." We're not seeking to admit that as part of our case in chief. And, you know, unless the defendant should somehow open the door to that and it become relevant through the doctrines of either curative admissibility or specific contradiction, and generally kind of discussed there in State versus Wimala. Other than that occurring, the state's not looking to have those statements that statement be available. "I am not answering any questions." So we're going to put that one to the side. But the other statement, "Either arrest me or I am leaving," does not come about as a result of interrogation or the functional equivalent thereof. Detective Riley is reading him the portions of the order, as he has been ordered to do by the court. That order stating that the Department of Children, Youth, and Families now has custody of Harmony, and that portion of the order also saying that the defendant is commanded to assist the Manchester Police Department in locating her and giving up her current information, her current status, and where she is. That's what Detective Riley is reading. The defendant's response, "Either arrest me or I am leaving," again, is not a result of a question. It's not a result of interrogation. So it fails the part of the test that we would ordinarily look as articulated in, from all of the progeny cases from Rhode Island v. Innis on down. It's not a statement. Reading the order of the court is not a statement that Detective Riley or any other officer in completing out a court order that they should have known is reasonably likely to elicit an incriminating response. Separate from that, what are the other statements that the defendant's asking you to suppress at this time? Well, there's the initial statement when Detective Dunleavy walks up to the defendant, and the defendant himself throws out sua sponte, "What is this?" Again, not a response that's being made in regard to a question that's being asked of him, and then the following questions that came afterwards. "Do I have to sign this?" Again, those are questions from the defendant. This case
the state has cited a litany of different cases in our pleadings. Most of them are set forth in State versus Thalusma, and that's 167 New Hampshire 481, where the courts have recognized that there's no need to provide any sort of Miranda warnings when they are advising or doing some administrative questions, or when they are answering questions being asked by an individual who's in custody. And that's precisely what happens here. The detective is merely answering those questions. Those questions are coming from the defendant himself.
I'm sorry, can you just restate the case that you just cited?
Yes, Your Honor. There's a large string of citations they all come from basically State versus the Thalusma, T-H-E-L-U-S-M-A. It's 167 New Hampshire 481. Refer to that, Your Honor, in our, specifically in our pleading, and I apologize, I don't think I have
I'll find it, that's
page.
fine.
But what you can see in there is that Detective Dunleavy's statements and the defendant's replies are not questioning, therefore they don't require Miranda. Just because a statement's made from police to a subject in custody doesn't mean that there's a violation of Miranda when the statements are volunteered by the defendant or by the person who's in custody. And Your Honor, I'll refer you specifically to paragraph 10 on page 5 of the state's objection. That is where you can see that citation to Thalusma, and you can also see that litany of different cases that clearly show that the statements that you're being asked to suppress here are, again, not as a result of some sort of questioning that's going on by Detective Dunleavy or the functional equivalent thereof. If there are other statements that the defendant is seeking to suppress after watching the videos, this is it. What was stated in their motion is his interactions with police, specifically referring back to me talking with Detective Riley and speaking with Detective Dunleavy. From those statements there, the state does not see any sort of interrogation that's ongoing. And so as a result, there's no violation that the statements should be suppressed. Specifically, again, the statements of either arrest me or if I'm leaving, what is this, do I have to sign this? It's not there. And so as a result, that's why the state's objecting to this particular motion. I'm happy to answer any questions that you may have on that.
No, yeah, I think it does make sense to kind of go motion by motion, and, yeah, thank you.
So first of all, the first statement to Detective Riley was, are you arresting me? As he has been given the order saying that he has to cooperate, or if Harmony is found, she'll be turned over to DCY. Detective said, I'm not arresting you. However, the court states that you must cooperate with MPD and tell me where Harmony is at this time. That was specific questioning intended to elicit a response with regard to the subject that they were suspecting him of. His response to, he has to tell the officer where Harmony is, was either arrest me or I'm leaving. I am not answering any questions. That response was an assertion of his right to silence. Then it was reiterated that provide me a location as far as being a father, and you owe that to Harmony. He reiterated his assertion, I'm not answering any questions. Then Detective Riley was done, and Detective Dunleavy walked up to Adam. And as you heard Detective Riley, he sort of passed Detective Dunleavy and shrugged or somehow communicated that he didn't get information. And Detective Riley then approached Adam and you saw that.
Detective Dunleavy approaches.
Thank you. Getting old. You saw that in one of the videos. You could, but it's between bodies and legs and all. And he approaches Adam, and he does approach with the intent of eliciting information from Adam. All of his statements and comments are to elicit information from Adam. He is requesting information from Adam. Now, one of the things that you look at is the totality of circumstances. And under the totality of circumstances, we start with that morning where Adam was stopped by police officers, and he was told that he was being detained subject to some detectives coming to speak to him. He told the officer he didn't want to speak to the detectives. Can't you tell them that I do not want to speak to them? The officers actually started questioning him a little bit, and then when the detective arrived, he immediately said he didn't want to ask questions, and the detective continued asking questions and trying to get information from Adam. Under that totality of the circumstances, this was the functional equivalent of interrogation, as the officer is saying. Get ahead of this. You want to get ahead of this. You know how to reach me. He's trying to get Adam to talk and for Adam to feel the urgency of the situation so that he will talk. So, and by the way, this approach by Detective Dunleavy is after Adam very clearly asserted his right to silence. Detective Dunleavy's statements were designed to elicit incriminating statements that Adam only answered in monosyllabic terms doesn't make the questioning any less for the purpose of eliciting incriminating information. So it should be suppressed.
Just briefly, Your Honor, the approach made in the afternoon is to inform him about the court order that has been issued that afternoon, as they were required to do so by the court, and his requirements under that order. Him asking, what is this? If that's the statement, and the other, it doesn't matter, Your Honor, if they did want to get elicited statements out of him. The question that's before you is, should his statements be suppressed? The question then is, what are those statements? And when the only statements there are, do I need to sign this? What is this? I'm sorry, but those statements, again, are not the product of questioning, regardless of what the intent was of the officers going there, which is clear from in this particular situation. It's to inform him of the court order and provide him service of that order, mandated and required to do so by the issuance, specifically from Judge Tennant. Oh, excuse me, I apologize, I'm forgetting the justice who issued that particular order commanding those officers to do that.
So I guess there's a bit of a misunderstanding there. I went on to the contact with Detective Dunleavy, who was talking about taking the cell phone, who was talking about, do you know how to get in touch with me if you choose to? All these things the defendant is responding to, that the search for harmony was not going away, that it would not look good if he was on the wrong side of it, that we've been down this road before, and defendant made responses to each of those questions by Detective Dunleavy, and that should be suppressed.
All right, anything further from the state on the issue of the 31st? Okay, very good. So let's talk about January 4th.
So, Your Honor, as to January 4th, the defendant has pointed to one specific statement as an assertion of his right to remain silent. And that's his statement, "I have nothing else to say," which occurred at approximately 8:49 in that recording. the defendant makes sort of a nebulous reference to continue to assert his right to silence, but without, as the state indicated in its objection, without knowing what specific points the defendant is referencing, it's tough to respond to sort of that nebulous assertion. So I just intend to reference just the one delineated point by the defendant of that 849 statement. I have nothing else to say.
Can I just stop you there so that is that your view, Attorney Smith, that the only thing that you're attempting to suppress is that one statement, I have nothing else to say?
No, I say from that point, he made his assertion and everything that follows, but I also said he's asserted it again and again. At each of the points that he asserted, if you're not finding an assertion in one place, you got to find it in another or another, because he asserted like 14 or 15 times.
That's how I read that. So I think they're indicating that he asserted his right against self-incrimination, and that was not honored. That's how I read that for the entirety of the January 4th statement.
So the way I read the pleading, and I'd be certainly open to understanding if I'm misinterpreting, but the pleading from the defendant on the motion to suppress statements from January 4, 2022 points specifically, I'm looking at paragraph 3 and 4, points to a specific reference by the defendant when he says, I have nothing else to say. And based on the context in those paragraphs of 3 and 4, including a partial transcript in paragraph 4, that would be a reference that in the video happens at 8:49 in the recording, that I have nothing else to say statement. But then the defendant goes on to just sort of vaguely assert, and I'm looking for this, in paragraph 5, Detective Dunleavy continues on, quoting now from the motion, Detective Dunleavy continues on and successfully got Montgomery to answer questions. Montgomery asserted his right to silence a couple of more times, which assertions were also ignored by the detectives, end quote. So I guess I'm addressing the one specific assertion pointed to in 849, but I guess my difficulty is, let's say the court rules that the purported assertion at 849 was ambiguous and was not a successful assertion. It's unclear to the state when the defendant thinks the next assertion was. There's no further specific identifications. So it's tough for the state to say this statement at 15 minutes or 20 minutes or whatever was or was not an assertion, because there's no other specific assertions pointed to or identified. So I'm intending to argue about that assertion at 849. I know the defendant says there were these additional assertions a couple more times, but without knowing specifically when the defendant claims those assertions were, it's impossible for the state to argue whether or not those were sufficient assertions. Does that make sense to the court?
Well, I understand what you're saying, but I think they say every time he says, I have nothing else to say, they may not have put a transcript in here, but I'm pretty sure that the defense is going to get up and say every time he said that, he was asserting his right to silence.
So if they do, then I'll respond. But as the court knows, and as the case law is clear, it's very contextual. The standard here is whether a reasonable officer in the position of the interrogating officer would have understood that the defendant was asserting his right to remain silent, which is extremely contextually dependent. And in fact, the state's argument as to that 849 purported assertion is that based on the context, it was extremely ambiguous. And here's why, Your Honor. This is explained more fully in the state's objection. But basically, at the time of 849, when the defendant says, I have nothing else to say, what's going on in the conversation is they're talking about the charges. And Your Honor saw in the video today that it was the defendant who sort of steered the conversation that way. He first asks about what the interference with custody charge was. Detective Dunleavy explains that. Then the defendant asks about what the second-degree assault charge was. And Detective Dunleavy starts to explain that, and it's in that explanation at about 849 when the defendant says, I have nothing else to say. So, as the court knows, and as is explained in the state's objection, the defendant was actually under arrest for 4 charges at that time: the second-degree assault, the interference with custody, and then 2 charges of endangering the welfare of a child. So, the direction the defendant was steering the conversation, asking about these charges, was incomplete. So it's the state's position that there were 3 equally reasonable ways to interpret his statement, I have nothing else to say. One, in the context of just the second-degree assault charge. Detective, immediately prior to that statement, Detective Dunleavy says to the defendant that this charge is about marks that were left on his daughter by him, by the defendant. And the defendant's immediate response is, quote, absolutely not, I have nothing else to say. In that context, it would be wholly reasonable to understand that as basically a verbal punctuation mark. I have nothing else to say, period. I have nothing else to say, end of story. In reference just to what Detective Dunleavy had just said about the marks on his daughter that were apparently left by him. So that's one reasonable interpretation of I have nothing else to say at that moment. Taking a step back, the second reasonable interpretation has to do with the overall context of the conversation. And that, again, is the defendant himself steering the conversation towards understanding what the charges were. They had talked about the interference with custody. They were in the middle of talking about the second-degree assault. They had not yet talked about the endangering the welfare of the child. It would be wholly reasonable to understand I have nothing else to say to mean I have nothing else to say about this charge. But it was the defendant, again, who was steering the conversation through an explanation of each of his charges, and there were still two that had not been discussed. And then, of course, I understand the third reasonable explanation would be I have nothing else to say at all, and I'm done talking. But the problem is, where there are three equally reasonable explanations, or equally reasonable interpretations of that statement, that is the definition of ambiguity. There's three equally reasonable interpretations of I have nothing else to say, sure, one of which may be an assertion of the right to remain silent, but that's not the standard. The standard is an unambiguous assertion of the defendant's right to remain silent. And that's not what this was, where there were those three equally reasonable interpretations. I mean, the fact that we're here today, an experienced judge, experienced attorneys, trying to suss this out and each making reasonable arguments about whether or not this was an unambiguous declaration or an unambiguous assertion, weighs strongly in favor of it being ambiguous. If it was unambiguous, it would be straightforward, it would be clear, it would not be subject to multiple reasonable interpretations. And because it was ambiguous, then the cessation of questioning was not required, because a reasonable officer, in light of these circumstances, would not have understood only that the defendant was invoking his right to silence, because there were other reasonable interpretations of that statement. So that's the factual nuance that a discussion of whether or not a specific statement was a successful invocation of that right to remain silent, which is again why I will come back to, I don't think it's enough to just say every time he said I have nothing else to say was an invocation. First of all, that's not what the motion says, but second of all, every single time he said I have nothing else to say, there was a different factual context and a different factual whatever going on, which is something I tried to highlight in the state's objection. But as to this statement at 8:49 in the recording, it was wholly ambiguous because of those three equally reasonable interpretations. And therefore was not a successful invocation of his right to remain silent, and the officers were not required to cease questioning at that time.
Thank you, Your Honor. First, it was interesting when I filed the motion, I indicated in the motion that Detective Dunleavy's report said that the interrogation ended at request for a lawyer, and I indicated in my motion that I didn't have that in my recording. Something must have happened that I lost some of it and did not have the ending of the interview at the time that I filed the motion, but that ending, I think, says a whole lot for the totality of the circumstances, because nothing changed, notwithstanding numerous assertions, until he said that he wanted counsel, and even at that, they still tried a little bit more, and he asserted it again, and it finally ended. So I'm going to start talking about the totality of the circumstances that start prior to that interrogation, and again, remind the court of my prior argument where Police Officer Stanzel got the body cam, and he advises out of Montgomery that he is being detained. Adam says that he does not want to talk to the detectives when they tell him that he's being detained for, some detectives want to talk to him. He says he doesn't want to talk to the police. Notwithstanding that, the detective asked him some questions and tried to put some pressure based on their expression of concern. And Detective Dunleavy appeared, and you saw the beginning of that. And although it does not appear that any of the officers told Detective Dunleavy that Adam had said he did not want to speak, the first thing out of Adam's mouth was that he didn't want to. And Detective Dunleavy said, yes, he said he didn't want to talk, and he repeated it. And on cross, but that the detective continued to question him, notwithstanding that he knew that Adam was saying he did not want to talk and answer questions. And he did that because he wanted the information. And that is exactly what was going on during this interrogation. The standard is, when there is an unambiguous assertion, you must scrupulously honor. So the first assertion, I think is it 2140? All right, man. Like, I don't even want to talk anymore. That is an ambiguous assertion. The word like is not adding ambiguity to it. It is a, what do you call those things that you just keep repeating? It's just a repetition. It's a form of conversation. But he has clearly expressed, I don't even want to talk anymore. The response to that is not him guiding the information or the interrogation to some other subject. The response to that was, we're just trying to figure things out. We'll give you the chance to speak. What they are doing when he asserts is ignoring the assertion, certainly not scrupulously honoring it, and pushing for more information. Let me check something, sorry. I'm a little discombobulated from the text stuff, so I'm a little... Let me see. Sorry, and I thought that I had that wrong when I saw my notes on it. It is at 8:49 when he says that were the marks left by you? Absolutely not. I have nothing else to say. And there's actually a pause there. And Dunleavy starts up, and the defendant says no. And Dunleavy says, we talked about how we were worried about your daughter the other day, right? What he's doing is pushing Adam. He is not honoring his assertion of a right to silence. He is trying to get more information from Adam in any way that he could, and he is pushing that interrogation. The totality of the circumstances include the detective's maneuvering for each of the assertions that followed, and that's when I was talking about at 2140. All right, like, I don't even want to talk anymore. Again, instead of honoring this, we're trying to figure things out. We're trying to let you speak. He says, I got nothing else to say, man. And Adam explains why he's asserting. And the police again say, you have the opportunity to explain. It's the time for you to explain yourself. 2555. I'm not saying anything else. The response, why do you refuse to talk whenever we bring her up? Again, that is an unambiguous assertion, and they are not honoring it. 2655, I got nothing else to say. The police talk about not caring for his daughter. He is not guiding these conversations. The police are bringing this up to try to get him to ignore his assertion and to push him into giving more information. On part 2, from the beginning to around 2 minutes and 20 seconds, it is a technique to try and persuade. I think you care about your product. Tell me you didn't do anything wrong. Help me. I beg you, help me. And this
I'm sorry, where is that?
That's the beginning of part 2, but it's still flowing from the 2655, I got nothing else to say at the end of part 1.
That's the exhibit 6, right? I think
Oh, sorry.
Am I right about that? Yeah, okay.
Okay.
And you said 2?
From the beginning to about 2:20, it is that effort to dissuade him from asserting, as he has already done. And that is what they're doing. They're trying to dissuade him from asserting instead of scrupulously honoring. At 2:26, oh, that was another issue, sorry. 3:05, I've got nothing else to say. And again, there's a pause and Dunleavy continues. 3:14, that's it, guys, I got nothing else to say. And Dunleavy says, make me a promise, man to man. This is not honoring the assertion. It is trying to dissuade him from his assertion. You're playing at 3:25, you're playing the same word games you did the other day. I got nothing else to say. And I think it was Detective Riley. It's 'cause we care, man. We want to know. That's an assertion, and he's clearly saying, we do not want you to honor this, or we don't want to honor it, we want information. And again, nothing else to say. I believe it's Dunleavy that says it's not going to stop. Get on the bus or get run over. At 3:40, he says, I got nothing else to say. And one of the detectives says, why do you have trouble talking about harmony? He is not maneuvering the conversation. He's asserting his right to silence, which they're ignoring, which, by the way, I will remind the court, they ignored the morning of December 31st, recognizing that he was asserting, and they continued, the Detective Dunleavy continued to question him. I got nothing else to say at 3:48, and what finally stops them is, I want a lawyer with me. So they honored nothing about his assertion to silence, but I want a lawyer with me was somewhat different from them. So they actually changed tactics a bit, started talking about the ex parte order at the end, saying basically it's the same as the other day. It does order you to help us locate Detective Dunleavy after Detective Riley gives him the ex parte order or says he'll put it in property. Detective Dunleavy prompts him again. It does say you're ordered to help us locate Harmony, but you tell us you're not going to do it. Again, he is pressing, even with the right to a lawyer being asserted, as well as the right to silence over and over again. Both of state and defense cited Lynch, and the state is saying that the defendant used words of equivocation. Well, the defendant, in Lynch, used words of equivocation. I think, possibly, I don't know. And the police officer in Lynch actually did what he's supposed to do if there's ambiguity, which is, are you saying you don't want to talk anymore? He went to clarify. These words that Adam Montgomery asserted, I've got nothing else to say, I got nothing else to say, I got nothing else to say, I'm not saying anything else, I don't want to even talk anymore, I got nothing else to say. Those are not words of equivocation. And from the police officer's response, they guide Adam and to distract him from his assertion and control still the conversation. Also in there is some case law out there that under a clear ambiguity, if it's not clear that an assertion is made, then the officer may not have to make sure. This was unambiguous. The officer, Detective Dunleavy, understood the same words in the 12:31 a.m. interview to be an assertion. It was an assertion here. The words were not ambiguous. If there was anything in the officer's mind because of context, at that point it's the officer to clarify, because there was no ambiguity in the words. Thank you.
Anything further from the state on that?
Yes. So this is exactly what I was referring to. The defendant's motion specifically addresses the statement at about 8:49 in State's Exhibit 5. But other than that vague reference to Montgomery asserted his right to silence a couple of more times, this is the first time the defendant is raising, and I stopped writing down the list eventually, but 2140, 2555, 2655, Exhibit 6 to 220, 305, 314, 325. At some point, maybe yes. At some point, maybe there was a successful and unambiguous invocation of his right to remain silent, but these specific assertions are so fact and context dependent. This is the first time he's raising and pointing to these specific moments. It's extremely difficult, if not impossible, for the state to make an argument based on the context of what else was being said immediately before and after 2140 or 2555, etc. So I would at least, at a minimum, suggest that if the court finds that the purported 849 invocation was ambiguous and was not successful, that the court, I guess maybe the defendant has done it, I would suggest the court ask the defendant to identify what's the next moment the defendant thinks he made an unambiguous, successful invocation, and give the state a chance to reply. Because this is basically the first time the state is getting notice that the defendant is pointing specifically at 2140 as a time when he claims he successfully asserted his right to remain silent. Without being able to, short of asking the court to pause and being able to pull up the interview now and look at the full context, the state's not able to reply to that at this moment.
So Attorney O'Neill and Wells, now that I'm thinking about it, as I had reviewed this, I was focusing on this issue about what did that one mean. But I do think that that one statement that was where we have essentially the conversation here. But of course, I hadn't seen the video. And I do see that they reference a number of other times when he says, essentially, I have nothing else to say. So I guess I'm a little, I don't think I'm going to preclude them from making that argument. And I think, the state has had the video, saw that he said that in some context over and over again. So I'll give you a chance to reply to it, given that it wasn't expressly asserted in the same way as the initial 849 statement, but I think I've got to address it. I'm not going to ignore it. I think it doesn't make any sense to start over.
Understood.
I don't think the arguments are particularly in difference, but I will give you a chance to respond to it. Do you have any objection to that, Attorney Smith?
No, and I'd probably ask for like 5 days after whatever deadline you give them to respond, and for me to respond to that 5 days after. Probably less.
But you've made your argument today. You were prepared for it.
Yes.
I've heard it.
Yes.
If I give them 5 days and give you another 5 days, then, each time we do this, the court has less and less time to consider these arguments. And now it's not the one argument that you outlined here. Now it's 6 more. So I'm not inclined to give you all another 10 days. I think it's, a reminder that if you want to make that argument, you needed to do it here so that they would have an opportunity to respond. Really thinking about it, is there anything in particular that I mean, what they're going to do is they're going to argue the context of it. You've argued the context of it.
And I would not have to respond to that because the context is on the video. I
Exactly.
agree. If there's something else that they bring outside of that that I think requires a response, I wouldn't even need a day, Your Honor. I could read through and just say, this is not correct.
So what you're going to do is you're going to look at those and you're going to file some, I mean, it's the same legal argument. You would agree there, right? You just
It
want to
is.
make a factual argument about why in context it is an ambiguous statement.
Correct.
Okay. How long do you think you'll need to do that?
Could we have until the end of the day Monday to file it?
That would be fine. And then, okay, I guess Attorney Smith, hearing that what they're going to file is an argument related to the context of those individual statements, and it's not a new legal argument, do you have any need to respond?
I can't imagine that I would, no.
Okay. So I'm not going to give you a response period if something, there was something urgently came up, you would file something immediately asking for the opportunity to respond. How about that? And maybe attach what the response would be, and then I will decide if I'm going to take it or not take it. How's that?
Thank you.
Okay.
Just two other things I wanted to say in response.
Yes.
First of all, and maybe counsel is misstating, but counsel in her argument made a reference to what officers are, quote, supposed to do, end quote, if there's ambiguity, is to clarify, but that's not what the case law says. Lynch says that it might be good practice for the interviewers to clarify an ambiguous request, but that is not made at any point a mandatory step that is required for the admissibility of the statement. That's just suggested as a best practice. And then the final thing I would say in response is the state disagrees with defendant's argument that basically the totality of the circumstances goes all the way back to the morning of December 31st. And that's because in this specific interaction on January 4th, there's a Miranda waiver. There's something very different. The defendant has been given his Miranda rights, and he has agreed, it's in State's Exhibit 2, it's in the video, he has agreed now that he is willing to answer questions. And in fact, I would recall for the court, at about 2:30 or so in State's Exhibit 5, I'm not precise on the timing, but in that window, when the defendant is reading through the Miranda waiver and reads that line, are you willing to waive each of these rights and answer questions? He, almost with flair, checks the box and says, sure, almost excited to have this opportunity to finally say something. So to say that this is just a totality of circumstances that goes back to 12:31 in the morning, the state disagrees. There's something very different that has changed. The defendant, sure, is willing to answer, has indicated he's willing to answer questions at this point. Does he at some point maybe invoke his right to stop answering questions? Yes. But in terms of equating what's happening on the 4th with what happened on the 31st, that Miranda waiver and the defendant's expressed willingness to answer questions is a very distinct change in circumstances.
And to what you said earlier about, is it possible that somewhere along the way he invoked? Obviously, if you identify that somewhere along the way, that should be in your pleading as well.
Okay.
Okay? All right, so if there's nothing further on that, Attorney Smith?
Your Honor, in response to two things that the state said in their argument just now, we are not contesting the Miranda waiver. It was a Miranda waiver. But the circumstances with regard to the police officer willing to violate Miranda protections on December 31st are relevant to what the police officer is doing on January 4th. They're both Miranda violations. One is, at both times did he assert his right to silence. At both times did the officer bulldoze forward to try to obtain information.
Thank you. All right, shall we move on to, one second. the motion to suppress the search of the phone.
Your Honor, I can address that on behalf of the state. The motion itself, is the way that I'm understanding what the defendant is arguing, is kind of broken into three pieces, but the state would argue that there's four. There's really the issue of standing, which has to be addressed first. And then separately, the defendants raised the issues of the exigency to seize the phone, the time period in between when the phone was seized and when the search warrant was sought, and then finally the probable cause to actually search the phone as well. Would the court prefer that counsel address all of those issues at once, or do you want to take this issue by issue?
I think you can just launch in and cover the territory, and then I'll turn to the defense and they can cover the territory as well. It
Will
probably
do.
makes sense to do it in the same order, starting with standing.
That's what I was about to say. I assume standing would be the first thing. The state would like to talk about that first, that's for certain. Your Honor, addressing those four things, I'm going to go into standing first. There's two-part analysis set forth by State v. Goss, and that's 150, New Hampshire 46, about whether a defendant has a legitimate expectation of privacy in a particular area. And that's when they've exhibited a subjective expectation of privacy and whether that expectation is one that society recognizes as reasonable. Here, Your Honor, we have a number of different cases, literally across the country, which has looked at this issue before of the concept of the ability to have standing to object to a third person's phone, the search of a third person's phone, which is what we have here. We have a phone that was owned by Kayla Montgomery, that was in the possession of the defendant. The first thing he does when he's asked about that with police is to say, "It's not my phone." So right from the beginning, he has no standing or legitimate expectation of privacy to another person's cell phone. He's denied ownership of the phone. And in this particular instance, the one exception that does exist for this, where if he were charged with possession of an item and that being a crime, he would have automatic standing to object to that. There's no automatic standing here. Ownership of the phone itself is not charged as a crime. It is not a crime in this fact pattern. For him to be using a particular cell phone, that's not a crime, so he doesn't have a standing to be able to object, to say that he's got privacy interest in the contents of that phone. Some of the citations that have been listed in the state's pleading, and I'll just go through them, that they are literally across the country, Your Honor. One we talk about is within United States versus Lindsay, which is a district court decision out of Minnesota. We also talk about Christensen versus the City of Boone, Illinois, which is a Seventh Circuit decision that goes all the way back to 2007. Also United States versus Curry, which is a District of Maine decision that goes back to 2008. All three of those courts, having previously looked at the concept of whether an individual has a legitimate expectation of privacy in a cell phone that belongs to somebody else. And all of those courts have found that there is no expectation of that personal privacy there. So he has no standing to object to the search of the phone because it's not his phone. Now, he makes that very clear with the officers, and it's clear also at the time that the search warrant is sought for that it is not his particular phone. And, Your Honor, that's kind of common sense, right? So we can think of many other instances where if I go to your house and some of my hair falls out and some of my hair is there, or if I leave paperwork that's there, or if I were to leave a fingerprint on an end table, I don't all of a sudden have standing to object to a search warrant, or maybe your consent, for somebody to take that fingerprint, look at that paperwork that I've left there, or take the hair that I've left on your couch. I don't automatically get a privacy right in where I leave my information, and quite frankly, that's what's happened here. He has left information, or there is information on that particular phone that's relevant to this case. Certainly, the defendant will have an opportunity to argue maybe that it's not him who's leaving that information there. Maybe it was the owner of the phone, maybe it was somebody else. But you don't have the standing to object to it when it's not your phone. And again, that's an issue that's been settled many different times over across the country. So we're not reinventing the wheel here. Separate from that, I'd like to jump to the exigency issue. as the defendant has stated here. It's also clear with regards to law here in New Hampshire that there is an exception to be able to take an item and specifically secure that item for a search warrant to be obtained for the court's review of whether or not the item should be searched. Exigent circumstances is nothing new, and it is an exception to the ordinary warrant requirement. It's got two elements to it. First of all, there has to be probable cause that that particular item has evidence of a crime, and there has to be exigent circumstances to take that, and it has to be a compelling need. State v. Rodriguez, 157 New Hampshire 100, states that exigent circumstances arise when the police face a compelling need for an immediate official action. And that compelling need we've seen in the videos, but it's also articulated in the affidavit that later on set forth the probable cause found by the court. And as we heard in the testimony here today, you have Manchester Police Department who is searching for a missing girl who has not been seen in what at this point in 2021, late 2021, is at least over 2 years. Defendant was unwilling to cooperate with police that morning to locate her. Therefore, they also, later on, he stated he had no phone. They spoke with the young woman that was with him at the time, Kelsey, who stated that, yes, he did not have a phone, and her phone had been destroyed in a toilet, had been ruined in the bathroom. And then what happens? We are now mere hours later. A court order has now been issued that DCYF has custody of Harmony where she is, and that the defendant has been ordered to cooperate with the Manchester Police Department to locate her. And when they find him, what does he have on him? He has a phone. Contradictory to what he said that morning, contradictory to what the woman who was with him said about him that morning, and even herself for access to a phone.
Can I ask you something about that?
Certainly.
So they take his phone, you argue, as I read it in your objection, saying they had to do it, there were exigent circumstances because of a concern that there would be information in there regarding the search for his daughter, and that it would be destroyed, that the exigency is the possibility that the information would be destroyed or altered. Am I right so far?
Yes, Your Honor. To that, I would also add that the phone would disappear. So I wouldn't have
Okay.
not just destruction of the evidence,
I see.
but also that phone then disappears.
Okay, and then nothing happens for some 30 days, and then a search warrant is sought. That search warrant is based upon what the police assert was a violation of a no-contact order.
That's
It's not
correct.
based on the search for Harmony Montgomery. Does that make any difference?
I would say, Your Honor, it doesn't make a difference because the violation of the no-contact order is unto itself evidence of what had happened to Harmony. Because we know that violation must have occurred based upon that phone in a time period after Harmony was missing, involving the two individuals, the two adults, who were in charge of her care last, and that would be Kayla Montgomery and the defendant. So the fact of the violation of that no-contact order, what communications they've had, what have they been saying to one another, and how he gets this phone, which is then found, remember, that happens just before, and gives the police that final piece to be able to issue that search warrant. And we've heard also testimony today that obviously police had other things that were going on in that initial crush to try to find Harmony and try to find that she's okay.
But the argument is that we better get that phone because it might be destroyed. That there's an exigency to the matter, right? And that exigency is that the information, that the phone or the information within it might be destroyed, and that information might lead us to solve a crime. And then at no time is a search warrant issued based on that.
It's not yet based on that. At that point, at the end of that day, when that is seized initially, and that is taken, Remember, what happens immediately afterwards is Detective Dunleavy testified today. He does go down and speak with the young woman that the defendant was with, who says that Adam has a phone. But then there becomes a question mark of whether that phone came from somebody else. The defendant denies that it's his, states that it belongs to a friend. There is certainly, what do we want officers to do? When officers have initial information and feel that there is exigency to protect an item from information being destroyed or information not being recoverable, literally walking away, we want officers, and we accept them from a policy standpoint, we want them to say, okay, there's exigency, stop. What do we want you to do? We want you to come to the court. We want you to stop, and we want to get you into the courthouse, and you explain to us why you want to look at something and what you need there. We don't want destruction of evidence. But at the end of the day, that particular day, when you then get these additional statements that it may not be his phone, it may be a friend's phone, we want officers to stop and consider all of the information that they have before they come forward to the court. And if there's a borderline decision, right, of whether or not there is, in fact, probable cause there, what do we want the officers to do? We want the officers to assess all of the information before making that decision. So there is a delay that's there, no doubt about it. But that delay itself does not
But it's not
the
just,
exigency.
it's not just the delay, I guess, that I'm inquiring about. It's the distinction between what they assert is the exigency to get that phone, which is the search for Harmony Montgomery, and then the search warrant itself, which is for, when they go to search the phone, they're searching it ostensibly not for that, that they have they're saying they have probable cause to believe that the crime was that he had contact, that Mr. Montgomery had contact with Kayla Montgomery, right?
A secondary.
In violation of a no contact order.
Yes.
And does that matter at all? That there's that distinction between those two?
I don't believe that that matters at all.
Okay.
Because the question of exigency is, again, we're down to just those two things of whether or not that we've got probable cause to believe that there's evidence on this particular item, or that if these steps are not taken, that evidence is either going to be destroyed or it's going to disappear. That's our question of exigency. Probable cause is it's there at the moment for exigency, but then also when we're talking about the four corners of the warrant, when we're talking about probable cause to do the search, that may, and as it was in this case, show actual probable cause of another crime that was there. And so just because when asked, the defendant here is asking that the suppression occur for a couple different reasons. A, for the seizure of the phone, and B, for the probable cause to search this phone. Those things are overlapping as they are here, but they are not nearly identical. If they had to be identical, then we would never allow any item, whether it's a phone or a car or anything else, to be searched for anything other than the original moment it was seized. If I believe that there's evidence in a car and I go ahead and stop that car there, what do we do? If we find out there's new things that we sometimes ask after the search has been initiated for the police to come back. But you can't say, well, we only stopped them because we believe there were drugs in the car, and well, now you think that there might be a gun in the car because you looked through the window. I'm not going to allow you to search for that. That would be the equivalent of here if we say that there has to be some sort of clear line that exigency and probable cause must match, and that's not the case.
Thank you.
No problem. So with regards to, again, I feel that the exigency, I think we've articulated it fairly well in the pleading, but you have, again, that possible deletion or alteration of data, as well as the possibility that that particular phone is going to walk away. And as, of course, once the search warrant is executed, it shows that the police there and law enforcement members, that their fears are well warranted because there was information that was on the phone. Talking about the delay now, going from that exigency to this period of 30 days in between, fortunately, again, there is a framework that's already been established. State v. Stacy, which is 171 New Hampshire 461, asks that this court will go ahead and conduct a balancing test of factors to determine whether there was an undue delay. And the state is confident that when you do, you'll see there's no constitutional deficiency here when you're balancing the nature and the quality of the intrusion again, intrusion into a third person's phone, not to the defendant's phone, versus his own constitutionally protected interest against, government, any sort of intrusion against, intrusion by the government against his privacy. So when weighing those things, when we look at the factors set forth in Stacy, weighing in support of this delay are the facts that the phone, again, was seized lawfully, that the police had diligently pursued the investigation throughout that time period. There was not a break in the action between the moment of seizure and when the search warrant was sought, that they were not working to try to find Harmony Montgomery and going into this next level of a violation of a court order that they had discovered in the midst of that. The defendant had never asked for his phone to be returned. His possessory interest in the phone is minimal at best, even if he did have standing, because not only did he not ask for its return, but a few days later, 4 days later, on January 4th, that's when he was arrested and held on preventative detention ever since. So he could not have possessed the phone, even if he had standing to it, even if it had been his own, even if police wanted to return it to him. That does not weigh on the scales in favor to say that there was an undue delay because he could not have used the phone. It's one of the things specifically that Stacy looks at. And then finally, again, the defendant denied that the phone was his. As soon as he was told that the phone was going to be retained, he denied ownership. The timing of the search that eventually was conducted pursuant to the search warrant, and as it was conducted to find with additional evidence, did in fact show that there is no undue and unreasonable delay that happened during those approximately 30 days in between when the phone was taken and when the phone was searched. If I can just have a quick moment, please, Your Honor. Lastly, Your Honor, getting to the fourth and final part of this, again, standing being first and foremost, but now exigency, talking about the delay, the defendant's last arguments in his motion speak to whether or not there was probable cause to be able to issue the warrant in the first place. We've kind of already had that discussion today in terms of the framework of deciding whether or not that's there, moving on to whether or not there is a material misrepresentation having been made. So I'm going to refer back to the state's pleadings and the objection on that, and also the objection that we filed with regards to Mr. Gorecki's testimony, because I feel some of that case law does apply for the court to be able to make its consideration of whether or not there was a misrepresentation that was there. But I want to take just a couple of minutes to talk about really what's in that affidavit. There are substantive paragraphs going through that were articulated by the affiant about how and why data could be compromised, edited, deleted, or corrupted. There are substantive paragraphs that are in there speaking about the concerns of whether finding out the true identity of the person that does own this phone and confirming that lies within that 4-day time frame or lies outside of it. Those are articulated in the affidavit itself.
But, so let me just ask you, based on the breadth of this affidavit, of the warrant and the affidavit, I mean, doesn't this sort of swallow the rule in the sense that every phone, if every officer could say, we have probable cause to believe that a crime was committed in these days and that it's going to be on this phone. And so we need to know, we need to be able to prove whose phone it is. We need to be able to look at all the information on the phone from the beginning of time until the day we got it. Doesn't this just suggest that there is no limitation to the search of a phone?
I don't think so, Your Honor, because I think it's very, very case specific. And it's also with regards to what evidence it may be on that particular phone, the probable cause to believe that evidence of which crime may be on that phone. So, for example, if I was involved in a motor vehicle accident today, police were to stop me and say, is this your phone? I say, yes, it is. Can we go ahead and search it? I say, no, they get a search warrant for that phone. What's the question? The question is whether or not Maybe I was using the phone during this accident. So the time frame would be very narrow as dictated by the offense that police are looking for to believe that there may be evidence of a crime upon. Here, in that situation, actually, let's stick with that situation for a moment. How do we know the ownership of the phone? We know it because police asked me, do you have a phone? I said, yes. They got it from me directly. I'm not indicating that this is somebody else's phone. I'm not saying whose phone it is. I'm saying this is my phone. It's the representation of ownership and possession of that phone. A lot of that has already been given by me. The fact pattern that we're dealing with here, let's say motor vehicle accident on a particular day, really constrains the time frames of that phone, because that's what police are looking at. That's what they believe there may be probable cause of, let's say, me texting or using the phone when I shouldn't have been and causing the accident. Instead, present here with what you have and as put forward in the, again, in the supporting paragraphs of the affidavit here, is you have a phone that the defendant is in possession of that he says is not mine. So there's a question of ownership of that phone. You have a time period that's being looked at. Yes, part of it is specifically for these 4 days, for the 27th to the 31st, to believe that there is a violation of that contact going on between him and Kayla Montgomery. But as also put forward in the affidavit, there has been specific facts alleged that these two individuals have not seen each other or been around each other for quite some time. You have I believe it's in paragraph 42 of the affidavit, and I apologize if I have that number wrong. But you have detectives articulating to the court that they went to confirm whether or not the no contact order existed, confirmed that it did exist, and then went to the additional, but there were exceptions. There were exceptions that contact could be had if it was for a legitimate family court matter. They then went the additional step to the family court to say, are there any pending matters? Is there any reason that these two should be having contact with each other? These no contact orders having been in place for a longer period of time than just those 4 days. So to look at that phone, in some instances, and with other cases, let's say my phone in a car accident today, there are limitations there with regards to time. I don't believe that every single case involves needing to search every single aspect of the phone. The aspects that were asked by the Manchester Police Department to search in this case fit with regards to the time frame for the multiple reasons to do it and for the fact pattern that they were presented with. Again, I don't believe that the court will go through and apply both Valenzuela and STEM, that the defendant cannot make a preliminary showing of some sort of deficiency with regards to the information that's on the phone. And I do want to talk a little bit about one thing that the defendant wrote down. The defendant, I can't remember, I believe it's paragraph 29 of his motion. He tries to equate the content of personal information with an expectation of privacy in that content. And let me just go ahead and see that. Thank you, Mr. Reading from the bottom of, the second sentence of paragraph 29 of the defendant's pleading. While Montgomery did not claim ownership of the phone, he did acknowledge that it was the phone he was using. Thus, it was likely, and indeed the affidavit anticipated, that it contained Montgomery's personal information, the content of which was private. The question set forth by New Hampshire law, by federal law, is an expectation of privacy in the item or the area to be searched, not the content of that area, not the content of the item itself. The defendant would have you believe that anything that has the content of his personal information communicated to others, he has a privacy interest in, where it's not necessarily there. Let's go back to that same analogy that we talked about before, where I come over to your house and I leave a fingerprint. That certainly would be, some people would say that's personal information. Maybe I leave paperwork that's sitting out in your homes. That, you might say, has personal information. Let's say that it is a bank statement. That doesn't mean that he then instantly has a privacy interest to be able to say, to stop you from giving consent for police to go into your home to collect those items. to stop police from doing a search warrant on your home, that's not a question of probable cause because it happens to be something of his privacy. The question of probable cause to go in is probable cause that believe that evidence of crime is either in an area that it needs to be searched, and he does not necessarily have this expectation of privacy in his personal information that he leaves elsewhere. When you click on I agree for, let's say, Apple or Google or one of these larger companies, and you are leaving your personal information, you're putting it out there. You pick up your cell phone and you make a phone call, and that leaves a toll record that's there. That doesn't mean that he has that privacy interest in this third item, in this third place, much as he's done here with somebody else's cell phone. And I bring this up when it goes back to the concept of probable cause, because when we are looking inside, not just from a standing standpoint, but whether or not there's probable cause to believe that there's evidence of crime in a particular location, you have a defendant who's saying, that's not my phone. And in doing so, that lends even more credence to the concept that there is probable cause to search the phone for the other reasons that are stated inside the affidavit itself. The trial court here is asked to look at that affidavit and say, could a magistrate have found probable cause from this? And from those, we believe that the answer is yes. Again, the standards articulated in Valenzuela, talked a little bit about in Tommy Page. I even found another case last night, Your Honor, with the concept that this information, specifically that searches are necessary for the extents that are articulated in the affidavit, that those searches are necessary because of the ability to deceive, to be able to hide information, to be able to destroy information, to be able to conceal its true nature, that certain restrictions on that are unreasonable. There's a large citation that we place in our objection to Mr. Gurecki on paragraph 12, citing cases from across the country, but I even found another one last night from our neighbor just south of here, and the Commonwealth of Massachusetts v. Henley, which can be found at 171 New England 3rd, 1085, which is a Massachusetts SJC decision from August 5th of last year, that held that, quote, although general or exploratory searches are not permitted, requiring a search warrant application to identify the specific locations or identify the files on a cell phone to be searched places an unrealistic burden on law enforcement and restricts legitimate search objectives given the storage capacity and file structure of most cell phones. So if that is true, if so many of these other jurisdictions have often found that restrictions on where to search in the phone or the timeline to search the phone are unreasonable, then certainly there's probable cause to search for the phone for the areas that are articulated by law enforcement in this case. Again, that goes to the concept of that probable cause. Your Honor, I apologize for being long-winded, but again, there are 4 different sections to go through there. Happy to answer any questions that you have.
So I don't have any questions. I think that brings us to the end of the suppression. Were you moving on to, what were you moving on to? Motion to sever?
No, Your Honor, I was going to sit down and allow defense counsel to respond.
Okay, so I'm going to have you sit down. That's great. I'm going to have you respond in just a minute. I want to take a 10-minute break. I want to give everybody a breather, use the restroom, then we'll come back. And then what I think we should do is, Attorney Smith, I'm going to give you a chance to respond to this, and then I'm not convinced that I need to hear from you on the motion to sever. I think I can do it on the pleadings, but if you've got a couple of minutes that you want to give to me on those, I want to make sure that, I'll talk to each other. But I wouldn't expect there was the need for any lengthy argument on that. Okay? Attorney Smith, good. Okay.
All right.
Okay. So then, looking at probable cause for the phone. One of the claims within the affidavit was that there was a court order that the 2 Kayla and Adam could not have contact, but there was an order that also, but the order also included that except as provided by the DCYF case, and then it goes on to say the DCYF case was closed. It does not indicate that the DCYF order did not authorize communication between the parties. So I do not think that they had probable cause to believe that there was an order in place prohibiting communication. You actually saw a discussion of that by Adam, but that's not in the affidavit. But what I am saying is that they recognized there was a caveat to the order, but they didn't go to see what they tried, but the case was closed. They would have to take the extra step to see what the DCYF order was to determine if contact was authorized in certain circumstances by the DCYF order. The second thing I have to say about the affidavit on the facts is I think paragraph 22 and a portion of 22 and 23 has to be stricken, and 24, although there's some information of when Crystal had or did not have contact with Harmony, the comparison to what Adam claimed needs to be stricken, as it was from the previously suppressed 12/31/21 conversation with Detective Dunleavy.
I mean, the fact that they agreed that they recently agreed that would be suppressed.
You've granted the motion to suppress.
Right, I understand, but does that mean that I excise that out of an affidavit?
Under State versus Gravel, illegally obtained evidence can't be used to sustain probable cause for a warrant.
Your Honor, I believe it's a matter just of terminology. I believe what Attorney Smith is just trying to argue is that it needs to be disregarded, not necessarily that it needs to be stricken.
Thank you.
So you look to see if there's probable cause with that redacted or discarded or, yes,
Right, thank you.
not considered.
Go ahead.
Also with the probable cause affidavit, it describes known contact between Kayla reaching out to Adam Montgomery in Maine. And the phone used was a landline phone that was switched to another relative's phone, another relative of his girlfriend, in Maine. No reference to Adam using a phone at all. The contact that was observed, according to the affidavit, was that Kayla was seen talking to Adam on that day by two different police officers outside of her residence. Again, no indication that a cell phone was used to set up that meeting, and quite the contrary. Adam had walked from the police, where they stopped him at Union and Lake, and walked over to Families in Transition and had the contact with Kayla that is referenced in one of the paragraphs. So you can't assume that a phone was used to set up the contact. If he knows where she lives, he goes over to where she lives, as he did, because they had the phone then. And he just walked over. So I think all of those affect the actual probable cause. The subsequent interviews that are discussed, not the interviews, I'm sorry, the subsequent evidence that they learned that Kayla, had on the 27th, they got information that the last phone that she had before the cops took it was, and I will just, the cheapest in Walmart and of the same ilk as the phone that was seized from Adam. It does not say that it's hers. Then there is the day after that there's surveillance video of the three of them, Adam, Kayla, and Kelsey, walking into Walmart. And they can positively identify them, and after entering, Kelsey and Adam separate. This is kind of important for a different reason, but I wanted to point that out before I went too far from the scope. So, now we have a request for a search. And in that request for a search, on paragraph 40, the affiant acknowledges the relevant time period is 12/27 through 12/31, and that's the time period that they want to determine if the two had communication over the phone. But as this bald assertion that deleted items may not have the correct times or dates or can be edited, other items I guess can be edited, they want all the information on the phone, completely all of it, whether inside the time period or outside the time period, and whether having anything to do with communication between Kayla and Adam, which is the purported reason that this warrant was granted. And how is it outside the scope? Because they've asked for probable cause to find that the phone may contain contact between the two during the relevant time period, and yet they asked for all the storage files, user attribution evidence, indicia of occupancy, indication of who has used or controlled the device. To find out indication if Kayla or Adam used or controlled the device is one thing. To get everything else about that device based on the probable cause as articulated and found by the judge, no, it's beyond the scope. They want to get everything to draw conclusions about how the devices were used and the purpose of their use and who used them. No, you've got probable cause about communication between Kayla and Adam during this time period. It doesn't open up communication with everybody else and how it's being used and what it's being used for. Identifying exactly how information is stored is a dynamic process. That's C under that. And this is what has to be pointed out on C. Whether data stored on a computer as evidence may depend on information stored on the computer and the application of how the computer behaves. This is a template. This is not a computer that's involved at all. It's a cell phone. This shows that it's a template, not specific or particular to this case or to the probable cause articulated. It's a template to get into every item that possibly can be gotten into. And then there's probable cause to believe the following data device will be evidence of crimes under investigation. The only crime under investigation that they said there was probable cause for that they were seeking was indirect criminal contempt. And I will again say what is articulated about Harmony, although the state said we can check any crime, there is no probable cause to go beyond what they have articulated they need for the investigation into contact between Harmony and Adam. But they want contact lists, address book, calendar, schedule, date books. That's beyond whether or not Adam or Kayla had contact. Text message history,
So
all of that
I'm concerned
within the
about
time
time.
period.
I'm concerned about the time, and
Yep.
I get the gist of your argument, and I understand that the court would need to go through each of these things. I don't want you to have to go through each of them. If you think I kept the staff very late yesterday, so I need to be cognizant of not doing that again today. So if you feel that this is going to be, if you have a lot more to do, then we're going to need to come back. So I just want to, I don't want to cut you off, but if you have a significant amount left, then we should talk about whether we're going to finish today.
I think one of the things that I pointed out and asked you to take note of was while conducting the investigation, there was no contact order except as permitted by the family court. Again, there is no family court order in there to say what the contact was. So the final issue, I guess, is privacy, that under Riley, the content of the phone is what is covered in the privacy interest. It is not merely the possession of the object, and I think I've cited Riley throughout to make that absolutely clear. But the other is the New Hampshire Constitution, that the amendment that was passed, and I believe it was in 2018. It was, by the way, right around the Page decision. It was not addressed in Page. And the other thing that I've said about Page is Page does not open the floodgates to you can go everywhere in the phone just by saying you need to. In Page, it was about the photographs, and unlike other stuff in the phone is connected to the cell tower. There is, that data is very different from photographs. And in Page, they talked about photographs. You have to go through them all to find out if they're evidence or not. And they can be attached from somewhere else to an email, so if only the photograph is saved, it might have a different date on it. All sorts of stuff about photographs that is not relevant to communication between Adam and Kayla, unless the state wants to say we have photographs that are beyond the time period, then it's a different argument.
All right, thank you.
Your Honor, I'm not going to go into addressing the different points about the case law. We stand on the cases that are submitted when you truly read them. I'm not going to go back through those and correct everything that's just been said a moment ago. The only thing I am going to say, Your Honor, is that we're rejecting any sort of implication that there's some sort of hidden material here with regards to what's on that phone. When you ask the question of whether the content of that phone has something outside of the scope, Attorney Smith stated that there's material here that she can't get into, material here that they have some material exists outside of the phone. That went into discovery back on March 17th. Defense counsel's office downloaded that back on March 30th. So if there's an implication there that the state has somehow hidden the information.
She's shaking her head. No, there's no implication about that.
My technical thing where I had to ask Mr. Gorecki, not that it's not there.
Okay, I didn't take it that way. I did not take it that way.
In that case, Your Honor, we don't have anything else particularly on this. We rest on the pleadings.
Okay.
Pardon me, Your Honor, just one second. We don't have anything else on this motion, Your Honor.
Okay, and on the issue of the motion to sever, is everybody comfortable resting on the pleadings?
I think we each had a couple minutes, but we're comfortable resting on the pleadings.
Okay. Should, for some reason, you feel the need, as you go home tonight, to say, I really need my 15 minutes on that, file something with the court, I'll get you in, we can do 15 minutes on that if we need to. Otherwise, I'm going to take all of this under advisement. It's going to be some time. We do have, so we have a final pretrial on October 27th. As I think you all know, I'm not seeing a standard dispo form here, which
we maybe wasn't done, but 15 days prior to the final pretrial, I require motions to eliminate. Not 5 days, 15 days. In this case, what?
You
Okay.
did have it in there.
So, I just want to be clear about that. Let me also just say, given the extensive nature of some of the litigation that we've had so far, it makes me, and given that there are a number of cases and a number of issues, to the extent you can file motions to eliminate early, please, please, please do. The court's docket is very full, and so finding time to get people in, if we need hearings, making sure that the court feels it has enough time to rule on them, I appreciate. So when you can, if you know something is coming, the sooner you file it, the court appreciates that. Okay? All right. Thank you.
Hello, hello. Sorry. Yeah, I was kind of in the shower when that ended. But I didn't think that Elaine was ever gonna stop talking. Elaine, aka Gingy, aka Vitus. The judge totally cut her off, didn't she, Rex? She was like, if you're gonna go on much longer, we're gonna have to reschedule this shiz because you're a little too long-winded for me, babe. Pardon me, I did not mean to cough in your ears. Gosh, crazy. Oh, look at this. I didn't see this 2 hours ago. CEO says, I love CEO. He's been a Roberta for 2 months. Ultra Dark CEO. Are you still here, Ultra Dark? Ultra Dark Hershey's chocolates. Well, good, happy girl. I'm glad you got your stuff done. I did too. I got a shit ton. I bathed both of my dogs outside, like bathed them. I got this Furminator shampoo and conditioner and this Furminator like brush thingy. And when you shampoo them, like it gets the undercoat. It worked really well, but I literally was covered. Look at Bella's butt is all poofy. Bella, you have a pretty tail now. Where's your tail? She always looks at her tail. You're jaded. Oh, because of Elaine.
Roberta.
All right, guys. Well, hopefully I am going to have a really good, I have something in the works for a Sunday night live, or Sunday live, I should say. But I'm not sure if it's going to pan out quite yet tomorrow. But I still have a plan B for tomorrow, Sunday night live, or Sunday live. Yes, I've got to get the sounds. I've got, don't their paws get dirty? What do you mean, Cray Cray? From what? Oh, you mean when I bathe them outside? No, I do it in the grass. Furminators are the shiz. They're the shiz gnat. But don't forget, if you have Lifetime, I think you can even stream it on their website, possibly. I'm not quite sure. Don't quote me on that. But tonight at 8 p.m. Eastern Standard Time is the Gabby Petito story, I think it's called. And if you look in the Gabby Petito playlist that I have a couple candid videos that from the recording from when they filmed it out in Utah. Everything happens in Utah. Why is that? Utah. A lot of people live in Utah. It's a big state. Is that why? I don't know. She doesn't know. She does not know, and she does not have that soundbite. Let me see if I have Andra's meow. Nope.
Roberta.
JB, we have to stand down.
I'm missing a ton of sound bites. I'm going to have to, there's some I need to clear out anyways. So maybe it's time for a new beginning of sound bites with some oldies and some newbies. I know. Ooh-wee, Rexy. That'll scare somebody. We're jaded from every trial. I can't watch it. I don't like that they made the movie. Yeah, I mean, they pretty much do that with every crime, but now they don't even wait. It's like they're doing it before trials, and we got Netflix coming out before Lori Vallow's even gone to trial. It's kind of crazy to me because we used to have to wait so long for these things to come through. We'd get a Dateline episode like a year after it happened. You know what I'm saying? Now it's like instantaneous. People want the news now. They want the latest now. Now. So now is your time to go watch your other favorite channels or go spend some time with your fam or, I don't know, text Jay, say hey. Are you going to watch the movie tonight, Mike Sanner? Because we'll have a live discussing about it. Ain't nobody got time for that. I got to get, oh my gosh, I don't have David's flute anymore. The flute stays. What do you think, guys? I know, without family consent. Yeah. I just think that it's crazy to do that, like the Daybell thing before a trial. But all right, Mike. I'm going to be waiting for your opinion as well. So let's reconvene. I don't know if it'll be tonight, though. I might fall asleep because I did a lot of stuff today and I'm really tired. So I might take her easy tonight. My back hurts. My everything hurts. But definitely tomorrow we'll have a discussion about it. So everybody, 8 p.m. lifetime. Or, dude, like DVR it. DVR it, Snow. Snow. Save the flute. I agree. Hashtag save the flute. All right. I'm going to go get in my comfortables for the night. You guys, thanks for watching this hearing with me. Craziness. We'll see what happens next in the case of poor little Harmony Montgomery. And that's why we keep coming back and doing this, is for her. Justice for Harmony. You guys have a great night. Mike Sander, keep the beer cold, dude. Got about an hour until showtime. We'll see you soon. Goodbye, Roberters and Robertolinos.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much.
Roberta.
I have heard enough about you and your problems. I don't give a damn. 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 You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time for that. Staying up late.